back to the seller.
Sure.
And then based on the bill, they will let you pay some expenses and stuff like that.
Okay.
So we're hoping there's a little bit of money there to
Okay.
do that.
Handle that.
Yeah.
Maybe in a week, a bunch of intelligence people will go vote.
Not much on mine, but.
You're asking for a lot there.
Turn some
Sure.
things around.
It's not a burden later, right?
Right.
Okay, well, we're getting closer there.
Okay, thank you so much.
Are you the IT wizard?
I try to be.
Now, you'll sign it, you will all sign in, I'll start.
I didn't introduce myself. I'm John Kohler.
David Ross.
Good to meet you, John.
Yeah.
Pleasure.
They were the only one that followed.
Heard a lot about you, a lot of good things about you.
Oh, well,
She got her A plus.
I appreciate it.
it.
We'll see, you know, seeing is believing. So
That's
we'll see
right.
how I do today.
That's right. I think,
I thought we had 20, so are we waiting on some?
I would imagine so.
Okay.
I know there are been some people that have expressed interest about joining virtually today.
Okay, yeah, no problem.
So what we've done, David, is we just, at the very beginning, just kind of set the expectation to say, we appreciate people being here, period. Because of having to manipulate and do different things, it might be best for those who are in Zoom to come off of mute and to ask their questions to you rather than putting it in chat.
No problem at all.
So prefacing that, at the beginning is always recommended.
Okay,
I'd rather people see the full screen presentation and you.
Sure.
Rather than have to try to
somebody
figure
else.
out.
Yeah,
the
yeah,
details. So,
I agree with you.
Yes,
It's
sir.
not within
I agree
2
with you.
days.
so,
Okay. They don't have to
Reserve
be
some
in
of
on that.
these, and some of these maybe.
Yeah, the clean, so everybody.
Can't give it to them virtually.
do you need a
You
clicker?
have one,
Yep.
that'll be a little easier for me to
Thank
Give me
you.
just a minute.
maneuver.
Yeah. Should be some still. If not, I'll make another pot. You all right, Jeff?
Yep. How about you, Andy?
Is there still some beer there?
I'll have to ask who it is.
I don't know about the pen, but,
You don't like my pens?
well,
Would you have fancier pens? I mean, you guys.
you know,
Those are the more expensive.
no, I like the pen, actually, the read down.
I see it, I see it.
My daughter.
Really? We could- I have no problem with Lloyd, Lisa.
Yeah. Yes.
I see that. You just like your old regular.
So blue ballpoint, now my husband would love this pen.
Well, you know what? I've gotten, it's generally it's 50-50. Either people like that pen or they like the cheaper pen. But I have so many of these pens, I gotta get rid of those before I buy them. I'm all for buying the cheaper ones.
The thing is I actually do like this. It's
Do you?
very nice. I like the way it flows.
Right.
You know, it's that, you know.
Well, maybe we'll keep both, just.
But I just had to say something.
No, I understand.
Caroline knows right.
Well, and she teaches a good class herself. What's she up
Well,
to?
that's why I came. I thought she'd be here.
Oh, Caroline? I'm very sorry to disappoint. And I did not get dressed up. You guys get the sportier version of me today. So don't hold that against me.
As long as you show up.
David, 2 simple buttons here, forward and back.
Even I can, I think.
This is why we get the simplicity is key.
Perfect. Hey guys, what's going on?
Who's all here?
Nobody can find the Zoom link, so I'm just letting you know.
It's on the training calendar.
I know.
I can't, I wish I could hold people's hands, Julie. I only have 2 of them, and one
Yeah,
of them,
we do too.
one of them's for my wife.
Good morning. John, we do too.
What's that?
Hold on, Andy.
I mean, you can hold your own hand, Joe, but this one's Katie's hand. This one's her favorite, and then this one can only go to someone else. So how do I can't split this 350 ways. I wish I could.
Good morning, Margaret.
Hey, how are you?
Tracy, I figured you'd be teaching this class.
No, I don't know this contract.
You don't like this one?
No.
Tracy said she wanted the best seat in the house, so she got it.
No one else is gonna sit here, so. I'm not trying, I'm just trying to smack in the middle. Yeah, there were people that did wanna see it by Zoom.
Yeah,
so
sure.
know
I see
that-
one already logged in. I'll give them
Besides, I'll be teaching the new contract for the next 2 months.
for
so-
CCRA. And well, I have noted some differences in this presentation between the two, but have not factored in maybe some of the stuff that's in the new contract, so.
Well, I have the new one draft format that I've just gone through and highlighted all the changes between our old one and this one.
Okay,
Maybe that would help if you look
well,
at
if
it.
if I'm, hold up, if I have a slide up and I'm referring to a difference between the state contract and the CCRA contract that's going to change, just speak up and we'll let them know that now. Everybody signed in?
I don't know, there are only about 6 people signed in, so.
I know, it's bad breakfast. Upstairs.
Those aren't from Colorado, right?
Oh, Joe, no, those are at home.
To sit through a contracts class on a Wednesday morning, I don't know what's required. Everybody got a folder at their seat? Looks like we still got 2 minutes, so we'll let any stragglers join us and get started at 10.
Now, in Saudi Arabia.
How's that?
The guy said, "Yeah, never got the pictures." And he said, "Now I got that." Let me know what I can do. You know what, but I can only do so much. I'm not gonna
Help
be your
yourself,
advocate.
right? Okay. As I said before, there's nothing better on a Wednesday than a contracts class. So appreciate you guys wanting to be here today. The topic of today's presentation is going to be the state realtor contract. As everybody, I believe, is aware, there is 2 different contracts that is used here in the Midlands, right? We've got the CCRA contract through our local realtor association that Tracy's heavily involved with, that is used prevalently through the Midlands counties. But we also have another contract that everybody else in the state uses. And that's the contract that we're going to be going over today, mainly because over the course of the last 2 years, we have seen an increased number of contracts or closings that are being used with this contract instead of the CCRA contract. So unfortunately for you guys, you're going to have to know both of them, because if somebody presents your clients with an offer on this contract, you need to know what it says, right? And the point today is to kind of give you a general overview of what's in this contract. Some of you may have already had one of these classes. In June of this year, there were changes that were made to the state contract that we're going to be going over. But today we're actually going to be going over the entirety of the contract for those of you that have not had a chance to go over this, so that you kind of understand what's in this contract instead of the CCRA. And we're going to try to point out some of the major differences between the two, so that you guys kind of have a red light or a light bulb go off for specific provisions of this contract that you know you have to advise your client differently than you would if you were using the CCRA contract. All right. From an introduction standpoint, I know most of you guys. My name is David Ross. I run the real estate practice at McAngus, Gowdlock, and Curry. For those newer agents or folks that are new to Keller Williams anyway, we have had a relationship with Keller Williams for going on close to 15 years now. And I know Keller Williams has grown in stature since those days. There was a house over off of St. Andrews that everybody was in this area. And now we've got 3 different offices, one in Camden now. There's a bunch of new stuff that is going on as Keller Williams has grown. And we've been happy to be a part of you guys' growth and partnering with you guys over the course of the last 15 years. That being said, part of the reason why we have been involved with you guys is to put on presentations like this, because our job is to make sure that you guys know what you're doing so that you stay out of trouble and can send us closings, all right? So part of our ancillary duties are to make sure that you guys have or answer any questions that you have about specific deals, and to try to educate you guys on contractual and other related issues that can come up in your transactions. So the way I like to give my presentations are pretty open-ended, right? So some of the best ways to learn are if you bring up some of your experiences, or if you have specific questions. I can guarantee you, if you have a question that comes up, you're not the only one that's thinking about it. You may be the only one that's willing to speak up about it. So go ahead and ask any questions that you guys have. There are no stupid questions. Contracts can be sometimes silly, and that some of the provisions seem simple, but they may not be simple. So go ahead and ask if there's any doubt about something that we're going over, okay? Yes, sir.
Before you get into the contract, I mean, with the market the last 12 to 18 months being like it was, I felt like I had a lot more contracts falling through than I did in the past. Did you guys experience that at your law firm as well? Because I'm only familiar with mine, but you see lots of contracts.
Sure, sure. Well, you know, several years ago, the escrow agents portion of the contract, closing attorneys started taking on more of, whereas, you know, now I don't know that there's hardly any contracts that Keller Williams actually serves as the escrow agent. But since then, yes, we've kind of noticed, because there may have been, if we weren't holding the escrow money, then we may not have seen a deal that gets terminated, because it may have been terminated before the contract got sent to us. But from our standpoint, certainly as the escrow agent, there has certainly been an uptick in files that get canceled, right? And, you know, one can only speculate as to the reasons for those, but my guess is because inventory is so low, what's left are not exactly pristine properties, right? So, and then now as the market is tightening on the buyer's side as well, from an interest rate perspective, people are not necessarily as willing to spend money on properties that are not so lovely anymore. So that may be one of the reasons why we're starting to see an uptick in canceled files. But I would agree with your assessment in that, yes, we are seeing more files or contracts that we get in canceled prior to the inspection period or during the inspection period. Folks that are joining virtually, I see there's a couple people that are on the TV screen. Certainly, we want you guys to fully participate as well. We do not have a chat list that is up on our screen. So if you guys would do us a favor, and if you have a question, just unmute yourself and yell at me. We'll be glad to answer any questions that you guys have as well. Now, I have inside your gray pocket or packets, I've given you several different documents, all right? One is a copy of the PowerPoint that I'm going to be going over, all right? And we have tried to conveniently put some spaces on the right-hand side of the document so that if you guys wanted to take notes, you can do so there. I have given you a copy of the state contract. Also included in this at the very back are two other South Carolina Realtor Association forms. One is a notice of termination, and the other one is a release of contract to buy and sell real estate. All right, both of which we're going to cover today, but I wanted to make sure that you guys had the actual copies of the documents because all of these go together. Now, one other difference that I want to make sure that we've impressed upon you guys, when you're dealing with the state contract, you want to use the State Realtor Association forms, all right? Because this contract, more so than the CCRA contract, it references in the contract, and the terminology that is used in this contract is consistent through the state realtor forms. Whereas if you try to use a form that we may use on the CCRA level, it doesn't necessarily use the same terminology or define terms as the Realtor Association documents, okay? So that's the reason why I've included these, because if you're using the state contract, the notice of termination is important as well as the release, because they're both using the same terminology that's included in the main contract. You have a great forward? Perfect, all right, good. All right, so some of this is gonna be review, but like I said before, we're not only going over the changes in the state contract, because quite frankly, there were significant changes, but they weren't that many. Before in the state contract, you had several different options from an inspection perspective. You could have a due diligence period like we have in the CCRA contract, or there was some other repair type procedures that some of which required the seller to complete certain repairs, but it also did not obligate the seller to agree to or have to agree to do any cosmetic repairs. So essentially, if you used one of the old repair procedures, the buyer didn't have the right to ask the seller to do any cosmetic repairs. And the buyer could not get out of the contract if the seller refused to do any cosmetic repairs. So that part of the contract has been taken out. So there hasn't been a whole lot of material that has changed, but there has been a significant part of this contract that has been removed in the updates from June of this year. All right, I told you guys who I am. Just one more brief note about MGC. We have 3 different offices here in Columbia. We've got offices all throughout the state. I man the ship in downtown Columbia. For those of you guys that have been to our office on Main Street, we're on the 10th floor of the Meridian building. We've got an office right down the street in Irmo off of Western Lane behind the Mungo facility. And then we've got an office in the northeast area located off of Two Notch Road, right where 77 hits Two Notch Road. Now, if you guys will notice as we get started here, what does the very first thing in this contract say? It's in bold and it's in capital letters. Parties are solely responsible for obtaining legal advice prior to signing this contract. Real estate licensees recommend obtaining legal counsel, right? That is not only a notice to your clients, but it's also a notice to you guys too, right? We have something called the unauthorized practice of law here in the state of South Carolina, and drafting contract language can sometimes be deemed to be the unauthorized practice of law. So if, and we got to be careful here, because there are, you're not going to go to an attorney to draft every single contract for you. But the reason why these contracts are so explicit is so that you don't have to necessarily do any drafting yourself. Although sometimes that's required in repair addendums and whatnot, but these forms have been put together so that they're trying to simplify the amount of contract drafting that you guys have to do to avoid you guys potentially doing the unauthorized practice of law. And that's the point of the second bullet point here. If for some reason you guys have a situation where you need to alter or amend the terms of the standard contract, it's always best that you shoot us an email or shoot an attorney an email just to get a thumbs up that says, hey, this works. Or if you don't have any solutions for a potential problem, we can give you the language that needs to be included in the contract. All right, we're going to start with the first paragraph. You guys can all see it here. We got a bunch of definitions in paragraph 1. We're going to go over what those definitions mean. Buyer seems pretty easy, right? But there's some other things that you guys need to be aware of from a practical perspective that you need to be doing if you're not doing. Use full names for us, all right? This is mainly from a closing attorney perspective. If you put John Doe on the contract as the buyer, and we have our title report come back, right? And there's a million John Does. Well, guess what? We have to automatically assume that all of those judgments are our guy, right? And we got to go bug the client to verify that, hey, you got a bunch of judgments against you. Tell us about this stuff, right? So in order to avoid some of that, if the judgments or the tax liens that we pull up in the title report are for John David Smith, and your contract, and you put the buyer's name as John Eugene Smith, we can automatically rule those out without having to bug him. All right, so it's always more efficient from a closing perspective. It'll be easier for your client, for us not to have to bug him about judgments or tax liens if you use full names. Now, if you're on the contract as a buyer, right, if you are putting a name in this buyer line, that means that you are contractually liable for the terms and conditions of the contract, okay? Which is a big deal, because if you breach the terms of the contract, if your name is listed as a buyer, you can be sued, okay? And we want to stress the difference between being a buyer on the contract and simply going on the deed, all right? Because there's another section in both contracts that allows you to specify who's going to go on the title to the property. And that's a big difference, because if you're going on the title to the property and you're not shown in this line as a buyer, you're not contractually liable. So you cannot be sued. So husband and wife, for instance, okay? If husband's really doing everything, or if wife is really doing anything, you may not want to put both of them as buyers. You may only want to put one of them as buyers, okay? And then whoever's going to go on the title, you put that in the subsequent section in the contract. And that means one of them is not going to be contractually liable or subject to be sued, all right? Now, one caveat to that is if both husband and wife are going to be borrowers under the terms of the loan, if there is a loan involved, then the lenders oftentimes will require that they're both contractually obligated on the contract. All right. So even though we want to avoid and try to help your clients avoid contractual liability, sometimes the lenders will require that they're listed on the contract as a buyer. Yes.
So if John and Jane Doe are buying a house, Jane's only on the title, John's only one on the mortgage. John signs the contract, but not Jane.
That's if I was in your shoes, that's what I would advise a client to do. Correct.
When we do a buyer agency, should they both sign the buyer agency still?
For y'all's purposes, I think you probably would want to do that, right? Number one, and this is more for your benefit than the clients, but now from a contractual perspective, you've got both people that are liable to you. Now, you are also alternatively liable to both of them, and you represent both of them. But in order to cover your bases, because they're going to own the property, I would probably put both of them on your buyer's agreement, even though you're not including both of them as a buyer on the contract. All right, sellers. Now, I know there's nobody in the Keller Williams family that would ever, when they're signing a contract, under the seller line, put seller of record, right? I sure hope not too. I haven't seen any from this group, but we do get contracts in sometimes that say seller of record, right?
Owner
Now,
of record.
say what?
Owner of record.
They're owner of
That's
record,
the old one
right?
from the 90s, yeah.
So we don't want to use that. If you get a contract that says owner of record, if you get an offer presented, that means the buyer's agent's being lazy and didn't look up in the tax records who owns the property, right? And if you get an offer like that, please strike that out and put your client's name so we know who the seller is, okay? The other thing we want to make sure of is specifically if you're representing a buyer, you want to make sure that you're contractually obligating all of the sellers, right? So if you get a contract that is filled out by John and James Smith, and you go on the tax records and you see that John and James Smith, but also Anita Smith owns the property, and Anita Smith is not a party to the contract. I don't know about your guys as clients, but I have not met a buyer before that wants to buy 66% of a property, right? And unless at the very end, when we figure out there's another person on the title to the property, if potentially that third person doesn't want to sell the property, your deal is done, right? So these are all things that we want to do. It seems simple in filling these lines out, but all things that you guys want to be verifying to make sure that you have a fully executed contract by everybody that needs to be included in the contract. So make sure you're checking the tax records to make sure that everybody listed there is listed. Now, if you guys are super duper agents, you may even, some of the tax records are not correct. Okay, oftentimes we'll see things that show up in the tax records not be accurate, or here's your key: if you see something that says et al. When you're looking at the tax records. What does that mean? That means, well, there's more people on the title to the property, We just don't have enough room to list them on this page, okay? So if you ever see at all, or if you really just want to make sure that you've gotten all the sellers included, you need to pull the deed, right? Lexington County makes that super easy, because all you got to do if you're in the tax records is it shows you the book and page of the deed in the tax records, and you can click on that, look at the first page of the deed, and make sure that whoever now owns the property is listed as a seller in your contract. Again, want to use full names, because not only are we looking up for tax liens and judgments for buyers, but we're looking at tax liens and judgments for sellers as well. And then if we have estate or trust issues, okay, these may not be issues, but they could be issues if you don't list an estate or a trust correctly on the contract. Okay, number one, a trust cannot hold title to real property. And this is not a trust class. We do a whole separate class on that. But for these purposes, a trust can't hold title to real property. A trustee of a trust has to hold title to the real property. So if you put in the David Ross Revocable Trust, you don't have the correct seller on your contract. It needs to state David Ross as trustee of the David Ross Revocable Contract. That is the correct way that they will hold title, because if the deed into them says it's going directly to the trust, that's an invalid transfer in South Carolina. So we've got some title issues. Also with an estate, all right? If your client is dead or you're buying a property from an estate, the seller line should not say the estate of David Ross. It should say John Doe as personal representative for the estate of David Ross, because the personal representative should be the only person that's authorized to bind the estate contractually. And again, there's a whole other slew of issues that we cover in another class, but those are the main things you need to be concerned about here for filling in the seller line. Yes.
So I've got a lot of, just making sure I did this right, power of attorney for their parents.
Yep.
So that's the same thing you said.
Yep. So if you have a power of attorney, it's a little bit different because it is an individual that owns the property. But a power of attorney, it does have alternative language. You don't want to put the seller of record in there. You want to put David Ross as agent or as attorney in fact for whoever the principal is that's given that power to the agent to be able to contractually bind.
The owner,
Say it again.
which should be the owner. And then you need to look at the power of attorney, make sure they do have a right to sell it.
Correct. That's exactly right. And Margaret's right. She's obviously taken my other class. But you're right. In all of these things, whether it's the state, whether it's a trust, whether it's a power of attorney, you hold it, the trustee has to be included, the personal representative has to be included, and the agent that's authorized to sign on behalf of the owner needs to be the one signing the contract. But step two of that is you really need to verify that they are authorized to sell or purchase real property for those people. And those should be found in the estate documents. They should be found in the trust documents. They should be found in the power of attorney itself. Yes, sir.
Now, you're figuring all this stuff out at the dining room table of the buyer's house when they're making an offer on a house.
Sure. I'm telling you, you got to do more work. I know I'm not.
How are you gonna get all this
No,
information?
The listing agent needs to fill in the name of the seller, just my opinion.
Correct. Now, it depends if you're the listing agent or you're the buyer's agent, right?
You're a
So
buyer's agent.
if you're the buyer's agent, right, and you get a contract that says estate of, or says trust, or there's a power of attorney involved that's not listed as the seller of the property, you want to, when you get that offer, you want to ask them for the authority documents, which gives the person that they've got listed there the right to sign the contract. Because the worst thing for you guys is you don't want to go ahead and sign the contract that's been presented, and the person that signed that contract is not the one that's authorized to sign the contract, and we're 6 weeks into the deal. We're a week away from closing, not 6 weeks. We're 30 days into the deal, and we're a week away from closing, and we figure out the wrong person has signed the contract, and the right person that can sign the contract does not want to sell the property, right? So that's the reason why it is important for you guys to do a little bit of homework when dealing with the state's trust power of attorneys, to get the backup documentation that allows or that shows the authorization for the person that's actually signing the contract for the seller. Yes, ma'am.
This is just to kind of respond to you also, but I have another question. Just as a listing agent, I love it when a buyer agent sends me a contract with a blank for seller and a blank for my information, because that way I can enter my information as I want it to show. And it saves, like, and I know my seller, I know who it is and how it should look on the contract.
Right.
Who's selling it. So that's just my preference.
Sure.
I have a complicated situation right now that I'm interested to know what you think should be on the contract. So I have an estate where the couple who held the property did not have joint tenants with right to survivorship, right? So the property, the one spouse passed, the property had to go through that spouse's estate, and one child was personally represented for that spouse.
Mhm.
Of course, then the second spouse passed. The property was not finished going through probate or whatever, but the other child was the representative for the other spouse.
Okay.
If you're following.
Yep.
So,
So you got two separate PRs for both individual owners of the property.
right.
Okay.
But there was nothing. Basically, the house, according to my seller, the one who represented the last spouse who died, the house went to
So,
her. It was gonna go to her ultimately,
okay.
right? So apparently now the other child's attorney has said that his name has to be on the contract also, because it wasn't joint tenants with right to survivorship.
Mhm.
Does that make sense to you?
Well, if it's still in the estate, yes.
So how would that appear?
Well, just like you would have John Smith and Jane Smith sign the contract if they were still living, you'd have personal representative A for the estate of John Smith and personal representative B for the estate of Jane Smith sign as the sellers of both of the deceased interests in the property.
Okay,
So you got two separate PRs, you have two estates that currently hold title to this property, both of which have to have a personal representative.
and are they both my client, even though the house ultimately only went to the one?
Well, has it gone to the one yet? There's some other questions. Was there a deed of distribution that was filed which transferred the title of the deceased, both deceased interests to the one person? Or has that not happened yet, and is the estate really selling the property? Because you can do what's called a deed of distribution, which is a deed from an estate perspective that the personal representative signs that transfers the property from the estate to the beneficiary or the heir. If that has already been recorded, then the estate is no longer involved. Once that deed of distribution has been recorded, then the grantee or the heir that received title to the property through the deed of distribution is your client.
That's really helpful. So another question I can ask people in this situation is, has a deed of distribution been recorded?
Correct.
And if the one says, I don't know, that probably needs to know, because they don't know what it is.
Right. So what you really want to look for is you need to see the estate documents. You need to see the authorization appointing the personal representative for both estates. And then if we're going a step further, you probably need to look at the will to make sure that the will authorizes the PR to sell real property. Because if the will does not authorize the PR to sell real property, the probate judge has to sign an order which authorizes the sale. Yes, sir.
If the seller's an LLC.
Good question. You would list the LLC as the seller because on the deed, the LLC is going to own the property. But it's the same proposition for authority purposes. If one person is going to sign the contract on behalf of the LLC, there should be an operating agreement or a resolution or some type of authority document where the members of the LLC have authorized this one person to sign contracts on behalf of the LLC.
And this is what I've been telling y'all for 2 years, and I did not tell him to say all this. Just so you know, we're not in cahoots.
Well,
But
sort of.
this is
but-
why it's asked for in command.
Right. Yes.
So I'm leaving that seller's line blank because I'm gonna get that information and make sure it's all right.
Right.
I gotta go back to the buyer and get that initial, then after.
Um,
No, buyer doesn't initial the seller line.
Well, it's just you're.
you're,
throwing something
yeah,
into the
I understand your
contract,
point is that
everybody-
you're changing the offer,
Right,
right?
and you might do it in two different places.
Sure.
How title and how, who's selling and.
Right.
Well, if it goes back to the seller and is filled in by the seller, you would still be ratifying even if they like
Right.
accepted it all through. So you'd be able to see if there was a change and know, okay, we're good to go on that.
From a
It's
legal,
only if they cross through
Yeah.
something that you would want an initial next.
that's what I would say too, right? So if from a legal perspective, I don't think there's anything wrong with it, but everybody wants to get paid, so we need to do what Tracy wants you guys to do. And I think just the seller line, you're fine. But like in the CCRA contract, if the offer comes back, the seller's filled out their name, but they've also put in items in section 18,
Oh, of course.
then we got it, then it's a different story, right? So I would say the seller line, for the purposes of this, so we can make sure that the seller is correct,
Right.
that's fine. But any other change that's included in the contract, we want to make sure that it's been initialed off again by all parties. Yeah.
One observation, as listing agents, we can make it easy for the buyer's agent by putting the seller's name as we want it to appear when you enter the data into MLS. So many listings, I see just the last name, and I have to go look at the tax records anyway, which what you said is great, but, and then the other one's a question. Let's say we have a ratified contract, and we realize there's a mistake in the seller name or something like that. Is the best way to make that contract change to do it with an addendum instead of altering the contract after it's ratified?
I think it's the cleanest way, right? Because one thing that gets very confusing is if you've got one particular term that has been negotiated and it's been crossed out 3 times and you got 6 different sets of initials, I mean, that's complicated, right? So what I would think would be a cleaner way to do that is to do a simple amendment that changes the definition of the seller pursuant to the terms of the original contract. All we need to have then is for the buyer and the new seller to sign the contract or the amendment, and then you're good to go. Yes.
I was just gonna say, I think it makes things so much easier when there's 2 agents involved. Like, you know how you want your buyer's name to appear, because that's like, they had to sign the buyer agency, and if it's a corporation, they're signing for themselves.
Right.
Yeah, so we had to do the legwork for the seller. We had to ask for those documents, and we had to make sure that they're legally able to sell the property, so there's no one better to know how it should appear and how they want it to appear.
Right.
It can be true for nicknames also.
Sure.
Like, some people want their name to appear like K. Ralph Williams instead of Carl Williams, you know, and the listing agent knows that better than anybody. And I agree with Brennan as well.
100% agree. With the main point of the last bullet point is if you have special situations where it's not individual buyers and sellers, you may have to do a little bit of homework to make sure that the person signing on behalf of the estate, the trust, the LLC is actually authorized to bind that particular entity. All right, the next definition is brokers. It's listed as brokers in here, but brokers include brokers in charge, licensees, and sub-agents. So there's not a separate designation for those types of brokers. Everything's included in the one definition. Closing attorney. Now here in South Carolina, you guys already know we are an attorney state. So you are required when a loan is involved to have a South Carolina real estate attorney represent the purchaser to do the closing. There are certain items that are included in closing, which are considered the practice of law. And remember, the very first slide talked about the unauthorized practice of law. And we're not just talking about you guys. Let's say that you had your buyer's got a friend who's an attorney, but he's licensed in North Carolina, not South Carolina, but he wants him to do the closing. Well, you could run into potential problems after the closing, if the closing even occurs, that could invalidate that particular deal. So you want to make sure that if you're on the seller side, or if you're even representing a buyer and they're wanting to use an attorney that you don't know, it's pretty simple to look up just to make sure and verify that if it's an attorney you don't know, that they're licensed in the state of South Carolina. Now, that being said, from a closing attorney perspective, it is a buyer's preference state, right? So the buyer gets to choose. That does not mean that the seller cannot incentivize the buyer to choose somebody that they want, right? So if you're offering seller paid closing costs, or if you're doing repairs, or if there's some other incentive that the seller is providing to the buyer, and the seller wants to use their own attorney, they have the right to say, I'll give you this, right? If you agree to use MGC as your closing attorney, or whomever you're going to use as your closing attorney, hopefully MGC. You see these in builder contracts all the time, right? There's nothing illegal about incentivizing the buyer to make their choice for whoever the seller would prefer to use, right? The buyer doesn't have to use that person. They just don't get the incentives if they don't use that. Effective date, all right, moving on. Now this is different. This is different than what we see in the CCRA contract, okay? So we'll read it together. The final date upon which a party to the negotiation places the final and required signatures and or initials and date on this contract, right? That's step one. And here's the second part that's tricky. Delivers notice to initially cause this primary contract to be binding on all parties. Okay, so obviously the first part of this is pretty simple. You gotta be signed and initialed everywhere. The second part, what does delivering notice mean? All right, and it's defined in paragraph 29. So everybody, let's turn to paragraph 29. Notice is a unilateral communication, right? Which means that one party is delivering notice to the other party. It can be through the broker, or it can be through the buyer or seller themselves that is providing notice. Now, it can be in a paper. It can be a paper copy that's delivered or mailed. It can also be an email. It can be to the address, the email or fax at the end of the contract, right? So in addition, look at the bottom of the signature lines. Right underneath where it says buyer, it says notice, address, email, fax. Underneath the seller lines, it says notice, address, email, fax. That is specifically included here for paragraph 29, okay? And you need to be careful here, because if you email the notice or the contract to an email address that you're familiar with, but it's not the email address that's listed here, they've got an argument that you have not provided notice. Even though they saw it, even though they opened the email, it wasn't to the email address that was listed in the contract. And that's what's required under paragraph 29, in that if you're going to deliver something either in writing, hand delivered, mailed, or emailed or faxed, it needs to be to the specific notice provisions that are included here. Now, oftentimes this will be blank, okay? So make sure that you're not one of the agents that are leaving this blank. You got to insert the contact information for the clients in this particular contract, because the notice provisions are so different from the CCRA contract. All right, yes, ma'am.
I'm asking, I don't love the state contract, but I just don't know it that well.
Sure.
On here. Delivers a notice. This is a really dumb question. On our contract, we have a ratified contract. It's ratified. You can see the day it was ratified there. That's what that is, right? Notice of what?
Sure, so it can be any notice, right? So it can be a notice of termination. It can be the delivery of a final executed contract back to the other party, right? So in the first paragraph, what we're talking about here is we're establishing the effective date of a contract.
Okay.
So buyer has sent an offer, seller has acknowledged and accepted that offer.
Right.
We're not done yet, right? Because the second part is the seller has to provide and deliver notice to the other party. So that's what we're talking about here. You are emailing back or hand delivering back or faxing or mailing back the final executed contract to the other party. So in that example, the seller sending this stuff back to the buyer. Okay.
So this is why I don't love this as much as ours, but I'll stop saying that.
Sure.
I think for clarity, when we send it back, if it's this, in the email, we say, you know, notice and note the day in the email, just so that we have that for our reference, but I hate that on the contract itself, it doesn't say.
Well, wait on
date
it.
of final notice.
Wait on it.
blah.
Because there's portion of this sentence, right? And we'll read it together. Only be effective as of delivery to the notice address and awareness of receipt by the broker, right? So everybody see that in the last line of that paragraph? So you're sending it back, but you got to have this other thing. You got to have awareness of receipt by the broker. What the hell does that mean? Right? And it's not listed here, but as the attorney, what I'm guessing this means, and for you guys as protection, what you probably need to do is when you send it, if you're going to send it by email, all right, you need to have the red receipt box checked. Right. And I don't know, you guys is, if you're sending it through DocuSign or however you're doing it, it may automatically do that, right? To show when they've received it. But that's a requirement of this contract. Just because you email it to them does not mean you have a ratified contract. So if you did that, okay, if you sent that and said, this is the closing date right there, or this is the effective date of the contract in the email, that may not be right. Because what if they don't open that email until the next day? So this is the part that deals with the issue that you're talking about. You have to have awareness by the other broker that you've delivered this notice. So whether it's a red receipt or when you send that email with the executed contract, you ask the other agent to respond immediately to indicate that they have received this email. Okay? Yes, sir.
If you send it through DocuSign, if you go to the envelope you send it in and click on history, there's a timestamp. So a timestamp when the email was sent to them, but if they open it, it also tells you when they opened the email in the history of DocuSign.
Okay. So your software may already do this for you. Okay. But if it's not being run through DocuSign for some reason, this is a requirement pursuant to this contract because you don't have an effective contract or a ratified contract until you have this awareness of receipt by the other broker. Yes.
Is it text?
No.
Is best practice to
Well,
not,
hang on one second. Maybe. Right? Maybe. If you've got a text that says, yes, I've received the broker or I've received the contract, that is, again, awareness of receipt by broker is not defined. So technically speaking, that may be sufficient, right? I would prefer if they text me, that I would text back, just, can you shoot me an email that just tells me that you've received the executed contract, just to cover all your bases there. Yes,
It
ma'am,
also
sorry.
said, sorry, or agreed by other parties, you can say, if you want to text, just say yours. Hey, can you text me when you get it or something? I mean,
Sure.
when they're agreeing, can you text me when you get the contract
Right. I think the point is we just need documentation
somewhere?
that the other party has received the final executed contract. Yes, ma'am.
okay, so for best practices for the notice, address, email, fax, should we just put our information in there? Because you wouldn't want to put your client's information in there, right?
I think that would be fine.
If we don't want to receive it through snail mail, then will we not put our office address and just put an email, fax number?
Whatever you put in there, and if you only put one, you are limiting the other party's ability to deliver notice, okay? But yes, if I'm sitting in y'all's shoes, nobody's waiting, in reality, nobody's gonna mail it anyway. Nobody uses the damn fax machine. Very, very few folks are using fax machines now anyway. So I think an email address, for practical reasons, would be sufficient to include there. Now you may want to, and I understand you don't want to necessarily put your buyer's information there, but you've also got.
Isn't it buyer's agent, seller's agent?
Exactly. The purpose of that line that you were just pointing to was to put the buyer's information. There's a whole separate section at the very back where you're putting your information along with your email address.
I know, but why would we want the other side of the deal to know our client's contact information?
Well,
Why do we want to give it to they gonna give me all work for it.
For- I understand, but for notice purposes, the intent of this is to make sure that everyone is aware.
But as their agent, when we're notified, they're notified.
Agreed. I would agree with you. And it says, oh, and notice, it says awareness of receipt by who? By the broker, not the client.
I mean,
So that you don't need confirmation that the buyer or seller has received it. You just need confirmation that the other broker has received it.
I get frustrated all the time because I feel like even our vendors don't understand what agency is, like a home inspector circumvents me and sends it straight to the client, not realize, like, no,
Right.
when I'm notified,
Sure.
they're notified.
Sure.
You know?
And what I would, the purpose of having this included in, you know, I do commercial work too, and it's in, you include the party and the agent and the attorney for notice provisions in most extensive contracts, right? The purpose of this is not to complicate things. It's just to make sure that if notice of any piece of this contract is being delivered, that not only does the broker know, which is it's legally sufficient to bind the buyer or seller, but from an informational perspective, everybody is aware at that point if it's sent to everybody. Now, what you may want to do is if you put the email address of the buyer, you may put in that line as well that notice is not sufficient unless additionally emailed to the broker, right? And the contract specifically says that as well with regards to awareness of receipt. So it should be already embedded that if they're sending something to the buyer, that they have to be sending it to the broker as well, because if they only send it to the buyer, we don't have an effective date. We don't have a ratified contract.
They could also be trying to get your buyer to initial something and circumvent you. I just don't recommend you putting your client's information there.
Me neither.
Well, and there's not, I don't think there's going to be anything that legally would give you some type of liability for not including that there. Because if somebody's providing notice, the only thing that's required in paragraph 29 is that the broker has received it, not necessarily the buyer. So it doesn't matter from a legal perspective whether you include the buyer's contact information or not. All right, any questions about that? And that was a major change, obviously, from the CCRA contract. All right, now, time seems easy, right? But this contract is Eastern Standard Time, right? So and there are different time period deadlines. You're going to see 6 p.m. as a deadline that's included in this contract. Well, if you're dealing with a client who's moving in from California, 6 p.m. to them is 9 p.m. to us, right? So make sure as the representative of your client that they understand that these time periods, hopefully you're not that pressed up against a time period. But if you are, they need to understand that 6 p.m. is Eastern Standard Time, not wherever they're located. Agency relationship, you guys are going to designate just like we do in the other contracts, what type of client are they? And then we're going to move on to the next paragraph, paragraph 2. Paragraph 1 took long enough. Are there any other questions about paragraph 1? Like I said, it seems simple, but look how many questions and potential issues came up with just filling out the blanks and discussing the definitions involved in this contract. Purchase price. Is it a cash deal? Is it a loan? How big is the down payment, right? These are all questions. I will tell you that this has a lot more blanks than the CCRA contract, okay? You have to be involved more in this contract, okay? Which is not necessarily good from y'all's perspective, but from the client's perspective, it gives them more flexibility, right? Again, we don't want you necessarily redrafting a contract, which is why the blanks are okay to fill out, right? We don't, all we're putting in here, even though these are material portions of the contract, it's not the unauthorized practice of law for you guys to fill out a blank. Now, if you were amending or changing some of the language in the contract, that could be looked upon as the unauthorized practice of law. So this does give you some more flexibility here to get the deal done pursuant to whatever the market conditions are or the specific needs of your client. Yep.
Sorry, I know.
That's
I'm
okay.
that person. Okay, every time I get this, I don't or if I have to fill it out for my client, because I'm not familiar, but they require it on the other side. It says contingent upon sale and closing of buyer property.
Mhm.
We are used to a sale and closing being only if their house is not under contract yet. If their house is under contract, do we still have to check that, or do we only check it if their house is listed but is not under contract?
Right, so we don't have the two types of contingencies, right? We don't have a closing contingency only or a sales and closing contingency in this contract. It's just contingent upon closing. So if we're looking in that box, the contract is or is not contingent upon the sale and closing of buyer's real property, okay? So that's a closing contingency. There's no alternative measures as to right of first refusal or any of the other more in-depth procedures that we have in the addendum that we use in the CCRA contract. Now, there is another form that explains the closing contingency definitions for this contract. That is an approved South Carolina Realty form, okay? Which is, again, if you're using this contract, you need to use the corresponding forms for this contract, not the CCRA contract, all right? Because they are not going to match up.
So I do have to check that box if their house is under contract and they have to sell their house in order to buy this house.
I would.
Okay.
Absolutely, because this does not, even though it's already been sold, hasn't closed, right? So you've only checked one of those boxes, not both of those boxes.
So what's SCR 504?
That is the form document, right? So the South Carolina Realtor forms all have a number that's associated with them. So that is the sale and closing condition or contingency form for the state contract. And obviously the major issues with the purchase price is figuring out what kind of, how are they going to bring their money, right? Is there a loan? Is it cash? And what I don't like is this combination of finance and cash. Well, hell, most deals are a combination of finance and cash, right? There's very few 100% deals. Now there are some, right? VA loans for one, and you've got other deals that we've seen lately, especially if you have a state housing loan or something like that, that's a down payment assistance loan, that there may be 100% financing, but most deals are going to be some type of variation between loan and cash because most loans require a down payment, right? So be aware of that when you're filling that out.
So those are considered the combination of finance. Most are considered finance and cash.
What I've seen.
I would put that, unless I know it's a VA loan, or I am 100% certain that there is going to be some type of 100% financing. Because even an FHA financing is 97.5, but that 2.5 or 3.5% that they got to put down, 96.5, whatever it is, that's a portion of cash, it's a portion of finance, right? So most deals are going to have that box checked.
So it says here, the verification of cash available for closing. I mean, so you gotta have like a photocopy of their bank book to include with the contract? I mean, I'm gonna say not attached.
Well, it does, you can put not attached. You can put not attached, right?
And then
That's
again,
not-
as far as the contingent on the sale of their house, if you got a contract on the house or whatever, I would think that if it's attached, you're gonna have to attach a contract copy of the.
And that's correct. That's exactly right. So you're not done, right? You're not done by simply checking the box that says this contract is contingent, right? You should be using South Carolina Realtor Form 504 in addition to this, which will explain the terms and conditions of the sale and closing contingency.
How many
Now,
pages is that?
It's one, and I just pulled it up and it's terrible.
it's not as in-depth as the options that you have in the CCRA contract, right? And this does not prohibit you from using the CCRA contract, right? But what I'm telling you is that there are defined terms in that reference the CCRA contract that are not referenced in this, right? So if you're using that, you're creating some ambiguity in the documents, which will give one of the parties the right to argue that this doesn't match up or there's some kind of contractual issue, which is why I'm telling you, if you can, and if you're stuck using this contract, you need to use their forms.
Stuck using this contract?
Say what?
Stuck using this contract?
Well, unfortunately, it's market dependent, right? So, you know, in the last couple of years, how many people have had an offer on the state contract and said, you got to redo it to the CCRA contract, right? I mean, sellers have had that option in the last couple of years because the leverage has all been on the seller side, right? But as we are beginning to see in 2023, things are not going to be the same.
So Keller Williams uses which contract?
Well,
Depends where you are in the state. I live in Charleston, I use this contract all the time.
correct. That's right. So
I live here.
and we have also seen in the last couple of years, there is a influx of agents that are now licensed in multiple jurisdictions, right? And if you got somebody that lives in Charleston that is also doing work up here, they're going to use the contract they're familiar with, right? Because everywhere else in the state uses that contract, not our contract.
A lot of the open door LLCs.
They're definitely going to use it. Yeah. And they'll probably make you use theirs. Yeah, right.
Must use this contract, you'll say that. Is that legal?
Yeah.
I thought we talked about this, Tracy, that if we receive, as a listing agent, we receive this from a buyer, we cannot.
You can counter back on the CCRA contract.
So basically you would just redo your offer on the CCRA contract and sit it back on the CCRA contract.
Okay.
Right? Because they can present this as an offer. You don't have to accept it. Right? You don't have to accept it.
You
Now,
can't refuse to present it to your seller though on that,
Okay.
but you can counter back on.
right. But be aware, right? If you got a listing in 2023 and that thing's been sitting on the market for 4 months and you get an offer in on the state contract, you may not want to push back very hard, right? Which is another reason why you need to know the terms of this contract as well. All right, property definition. Now, there's one provision in here. This is going to explain to us what is included in the property that's being transferred. And what the seller's obligations are with regards to the property. Seller agrees to maintain the property in operable condition, right? What does that mean? I don't necessarily know. Some of the potential issues could be, you know, you got a pristine HVAC unit when you did your inspections, but it has some issues during the closing period, right before closing, or the contractual period, and still operating, but it's no longer in pristine condition. Is the seller obligated to put it back the way it was? The CCRA contract says that. It requires the property to be in the same condition as it was when the contract was signed.
Or better.
Or better, right? And the seller warrants that there's no hidden issues, okay? Which is another big deal here because this contract does not have any language in it with regards to the seller warranting that there's not a hole in the floor underneath the rug, right? The CCRA contract covers that. This contract does not.
Well, wouldn't that be covered under seller disclosure?
Should be, but it's not specifically spelled out like it is in the
Yeah, a hole in the
CCRA
carpet
contract.
isn't on the property disclosure.
I'm talking about the floor, right? So if there's a hole in the hardwoods or there's some damage to the hardwoods, they just covered up with the rug. That's what we've seen a couple of times in the past. That's not permissible under the terms of the CCRA contract. It may be permissible here, right? Because there's no language here. I would say it's going to be an issue and we deal with it before closing, but the purposes of this class is to go over what's in the contract and what's not in the contract. Now, what's being transferred? The land, any appurtenant interests, any improvements, landscaping, systems and fixtures are going to be conveyed with the property or as part of the property. Appurtenant interest, what is that? Appurtenant interest means property rights that the property being sold has that benefits that property, right? So that means if you have a piece of property that is being sold that is not connected to a county maintained road, but it has an access easement through the neighboring property to granted access to the county maintained road, that is an appurtenant interest. That is an interest that does not, that's a property interest that's not on the property being transferred, but it is benefiting the property that is being transferred. So all appurtenant interests are being conveyed. Yep.
So weird question. I ran this a few months ago. in the low country, not on a deal that ended up closing, but part of the reason my buyer liked this property was it had an agreement with a lot next door that had a dock on it. Would that have been covered in this transfer? They ended up passing on the property.
So the dock was not on
Was
that
not on
property.
their property. line,
Correct, but they had an
it was a-
easement or a right, they had a legal right to use the dock, is that
Yeah, they
correct?
had a contract, basically, I don't think they had an easement, was my understanding, but they had a contract, like an actual paper contract with the owners of the other property that they were allowed to use it pretty much whenever.
Yeah, sure. So question number one is, if that document, does the document, has it been recorded, one? Okay, because if it's not recorded, it does not run with the title to the property, so the new purchaser may not be getting those same rights that the seller had. And number two, does the document have language in it that says that this agreement is binding upon heirs, successors, and assigns, right? Because you can have a document, even if it's recorded, that's only between the two parties that sign it. If there's no language that says this is binding upon whoever buys these properties in the future, then it ends when the title gets transferred. Okay. What's an improvement? Improvement is a permanent addition to the property that's designed to make the property more useful or valuable sometimes, right? I've seen some improvements which don't necessarily improve the value of the property. Systems, plumbing, HVAC, sprinkler systems, security systems, right? Now, we have a long list in the CCRA contract of what is included and what is not included. Unfortunately, this contract does not do as good a job as the CCRA contract. This is what we've got. Fixtures. So, and we're going to get to this. Look at the bottom bullet. We're going to go over all this stuff that's included, all of which is general in nature, right? Fixtures, something that's permanently attached to the property. It's nailed down, it's bolted down, it's screwed down, it's within the plaster. The point here is, if there's any doubt at all as to whether or not something is supposed to be included, this section has, parties agree that no personal property will transfer except as described below in the attachment. Down in this line, at the very bottom of page 1, when in doubt, put it in. Okay, so if you're expecting the security system to transfer, it needs to be in there. If you're expecting the Ring doorbell to transfer, maybe a fixture,
That's now the new CCRA contract.
maybe not. What is it?
Ring
Ring
doorbells,
doorbells?
yeah.
And they do a fantastic job in our contract of clearly delineating what's included and what's not. The point here is, if you are in doubt, right, you need to put it in this line to make sure that it is going to be transferred for your client if that's what their expectations are. Any questions about what's being transferred? All right, now this part is very interesting. We're still in paragraph 3. HOA dues, common area assessments, condo regime fees, parking, storage areas, memberships, lease issues. All of this stuff is specifically listed here as the buyer has had the opportunity to review these issues prior to entering into this contract. Okay, now think about that.
Yeah.
What does that mean?
It means there's a lot of burden on the agent to try and know this stuff, because how is the buyer supposed to know?
100%, right? Because what's the buyer's response going to be? Well, the agent didn't tell me anything about it, right? And once you've entered into this contract, do you necessarily have the right to back out of the contract if there's something in the restrictions that you didn't like? I don't think you do in this contract, because it's specific and it says you had the opportunity to review all of this stuff prior to entering into the contract.
Can you write in, you have 10 days to review those?
Well, you're going to have 10 days of the inspection period, right? So there is a fail safe here. But as we're going to talk about it, the inspection period in this contract is different than the inspection period in the CCRA contract, because it's probably not going to be a free inspection period. It's going to cost the buyer money to get out of the contract during the inspection period. And we're going to get there, but keep that in mind as we're going through this, which is why you don't want to rely on figuring things out in the inspection period, because if you get into the inspection period, you don't like the covenants and restrictions, or you don't like the regime fees, and you don't like the lease agreements that are in place, if this is an investment, you had to have researched this and looked at it before closing. You could cancel it during the due diligence period, but there's going to be probably a termination fee that the buyer is going to have to pay in order to cancel the contract. So again, unless they're willing to sacrifice that termination fee, you want to make sure that they are aware of this, and we need to look, if they're worried about it, they need to make sure that they're reviewing this stuff beforehand. And from y'all's perspective, may not be a bad idea if they say, I'm not worried about it, that you get them to sign something that says they're waiving their right to review these materials prior to entering into the contract. Yeah.
On the seller side or the buyer side, is the selling agent responsible for making all this information available? Or as a buyer, do you have to research all this stuff? Because if time becomes of the essence.
I completely understand. I don't think this is reasonable at all. However, there's nothing in here that says they have to provide this stuff to you.
So we'd have to write it in the section that the buyer, that this number is also part of due diligence or something.
Correct. Well, and you can get out in the due diligence, but there's going to be a termination fee. So you could review it during the due diligence period, but in order to terminate the contract, if you don't like what you see, you're going to have to pay to get out. You can, and we'll get there, but it depends on the market, right?
Right. Oh, it's take us an hour to do page one. People think my classes are too long. I'm at 4.5 hours.
And I generally talk faster than this. Anybody that's been in the closing knows. We'll pick it up. All right, now filling out the property, right? This is the main stuff that you guys have to fill out here. What's the TMS number and the address, right? Really, from a title perspective, that's all we want to see. All right, I don't need the lot number. I don't need the subdivision. I don't need any of the other stuff that's mentioned there. If you have it, great. But what we don't want you to do is to guess, right? Because you put the wrong thing in there, and we search title to the wrong property. And when I'm going over the survey at closing with the client, they said, no, I'm not buying that one, I'm buying that one. Well, that ain't what we searched, right? Now we would have seen the seller doesn't actually own that one, but there's gonna be an additional cost for a title search because somebody has searched the wrong property because of the information that's been inputted here. So keep it simple. The correct TMS number and the correct address are really the only things that the closing attorneys need in order to perform their title search or to order their title search. Yeah,
TMS number would go under tax map.
correct. That's right. TMS number is tax map number.
If it is being subdivided, do we put part of and then the tax number so that you guys know?
Yes, and that's why I've got that specifically on here. Run into a bunch of issues with this. If, number one, there's multiple reasons why we run into this. If you have a client that's selling a piece of property, he owns 5 acres and is selling an acre of it. Okay, that acre does not exist until a recorded approved subdivision plat has been recorded and approved by the county. So you can't enter into a contract that is agreeing to sell a piece of property or an acre of property out of a 5-acre parcel because that 1-acre parcel doesn't exist. It doesn't have a separate TMS number. It won't have a separate TMS number until the year after the plat has been recorded. So that's the reason why we want to make sure that we are putting in specific information if your client is purchasing a portion of a piece of property that the seller owns.
Are they even allowed to sell it if they've got a loan on it? And the loan is for the entire 5 acres?
Sure, you can, but typically what happens there is there's a partial release of the mortgage, right? So if you got a mortgage on the whole 5 acres, we order a payout, we'll have to coordinate with the lender that they're going to sell off an acre of this. And let's say they owe $200,000 or $250,000 on the mortgage. Well, in order to release an acre of it, they've got the release fee is $50,000. So when the seller sells the acre, they got to pay the bank $50,000 and they'll release the mortgage from only that 1 acre, but they'll keep it on the other 4 acres.
Or I just had one where they sold an acre out of 3 acres, but just the value of that acre was enough to clear up the whole mortgage. So they just paid off the
Yeah.
whole mortgage.
And then they've got the other 2 free and clear.
And they had it all free and
Correct.
clear.
And that's been done before as well. The main reason why we're worried about the TMS numbers in this situation, because this has happened to me, got to the closing table and they had the tax map number on there. Don't have anything with regards to the acreage. There's no information about this being a portion of the parent tract. They've got the parent tract TMS number, the parent tract address, okay? And we're going through the closing documents and we got on the deed all 5 acres, right? Because that's what the contract says. TMS number is matching 5 acres. The address matches 5 acres. No other information has been included in this contract. So when we get to the deed and we're going over the property, pull out the survey, you're buying all 5 acres. No, seller says. We're only selling the front corner of it. Well, you can't sell the front corner of it because that front corner is not a separate piece of property. And that obviously delayed closing for several weeks until they eventually got the subdivision plat done and approved. But you need to be aware, specifically, even if you know and it has been approved, the tax map number will not be assigned to the new parcel until the year after the closing. So if you put the tax map number and the address, even if there's a recorded subdivision plat, which we will pick up if it's been recorded, but oftentimes it's been approved and it doesn't get recorded until closing. You need to make sure, like Tracy has said, if you're aware in advance that this is a portion of a parent parcel, when you put that TMS number, you need to put P/O, portion of this tax map number. Okay, I would also put in the somewhere in this line item, put an asterisk that says 1 acre has been subdivided from the seller's property. Something that tells the closing attorney that we have a subdivided piece of property here. So when we go to do the title search, we're specifically looking at that property and what needs to go into making sure that the 1 acre piece has been approved in order to effectuate the closing.
And where do you put that?
Just in the address or in the TMS number, right? So if you put in that where it says tax map on here, just put P/O, the tax map number, because the new tax number doesn't exist. This piece is a portion of the bigger parent parcel tax number. And then you can just anywhere on the contract, just put an asterisk, say property has been subdivided.
Did you attach a highlighted plat?
Oh, I would love you for it. Great, be great, yeah. I've never seen that before, but you're certainly welcome to do that. We would appreciate it.
That would be on the CCRA too, right? I mean.
Yes, that's in general, right?
Okay.
All right, we've already talked about listing items of personal property, even if it's not personal property, even if you think it's a fixture, right? If the security system has been bolted down, even if you think it's included, put it in here for safekeeping. All right, closing, paragraph 4. All right, this is different. Closing occurs when seller conveys the property. Okay, what does that mean? Well, it could mean a couple of things. Does that mean when the deed gets recorded? Does that mean when the deed gets signed? A deed is effective between the parties once it's executed. It's not effective for the rest of the world until it gets recorded. Okay, so what I mean by that is if I sign a deed and I give a piece of property to Tracy, but I also sign a deed and give the same property to Margaret, okay, and Margaret records her deed and you don't, well, of record, she's the owner of the property, okay? But she still could sue me because that deed was effective between the two of us as soon as it got signed, all right? So I think for the purposes of conveyance in this contract, we're talking about when the deed gets signed. That's when the closing occurs, which also leads to more issues because sometimes deeds get signed before the closing.
Our CCRA contract says when attorney disperses.
Disperses, right,
Yes.
exactly. This does not have any language in here about disbursement, right? So we've got this conveyance. Now, I would take in reality, recording and disbursement is what happens in a conveyance. But if somebody's arguing the language that's included in the contract, this is what it says. All right, it says must be no later than 5 p.m. on or before a certain closing date. Who's been in a closing after 5 p.m.? Right? I know I have. What does that mean? Well, does that mean if sellers really want to get out of the deal and they get sneaky and they schedule a 4:30 closing and they're watching, you notice they're watching the clock pretty well. And as soon as that thing hits 5:01, hadn't closed. I don't want to sell the property anymore. Does that give them the right to do it? Potentially. So be aware that, again, we would always advise people to not schedule your closings on the closing date pursuant to the contract.
Why would they put 5 p.m.? Why not 6 p.m.?
It's 6 p.m. is in other parts of this thing. Maybe the closing attorneys that were involved didn't want to be doing late closing. I don't have an answer for that. But build in some time, right? Because you don't want to give the seller the option to walk out at 5:01 if you're using this contract. So I would schedule closing the day before or in the morning to make sure that you're not giving the seller any outs, because this potentially could provide the seller an out. And again, the bullet point about the CCRA contract, it does state that closing occurs when the attorney is authorized to record the deed and when money is dispersed, right? Now, what does conveyance mean? And this is again part of paragraph 4. Fee simple title. Fee simple title pursuant to this contract is subject to easements, restrictions, rights of way of record, provided they do not render the title unmarketable or negatively affect the value of the property. Now that's a lot, right? But that's dangerous language. Because just like when we talked about, there's provisions in the contract already that say it's up to you, buyer, to know what you're getting into with regards to the title to the property, restrictions, leases, anything else, before you enter the contract. Buyer beware here. The definition of conveyance means that you're taking title to the property subject to all of these things. There is no title objection period. What this means is if your client as a buyer wants, you know he wants to put a pool in the backyard, and subsequent to the execution of the contract, 2 weeks later, we find out there's an easement that goes through the backyard and you can't put a pool in the backyard. Well, you've signed a contract that says you're taking that property subject to easements, restrictions, and rights of way of record. Okay, so your buyer is one unhappy camper because now he's got to either purchase the property and not be able to use it for the intended purpose, or it's going to cost him money to negotiate a termination of the contract. Yes, ma'am.
I was taught almost from the jump that if your buyer wants a pool, you need to make that contract contingent on the buyer being able to put a pool in.
Excellent idea.
Because that way you're not gonna get somebody coming after.
That's correct. And that would supersede this. All right. That would supersede this. And the buyer would then not be obligated to purchase the property unless they could use it for their intended purpose.
And it would save a whole bunch of waste of time too, because if the seller knows there's some reason why a pool can't go in before the contract's ratified, they're gonna be like, well, hey, there's this thing, and that's not gonna work.
Exactly.
It just makes me wonder if like sellers like down in Charleston or something have to like have pups come out the day before the listing goes live, just so that people can see where all of this stuff is.
They don't do that.
I know, but
Don't do that.
you almost think they should, because all this language is like, you're gonna have to pay to find this information out when I can call for free.
And again, I should have said this to begin with. This contract has gotten better through the revisions in June, but this is a seller contract. This is a contract that benefits the seller without a doubt. All right, now, the main point is you cannot get out of the contract for easements, restrictions, anything that is involving the title to the property, unless it negatively affects the value of the property, okay? And the fact that you can't put a pool in does not negatively affect the value of the property. The only thing that would negatively affect the value of the property is if the corner of the house is encroaching into the easement. Then you got a title issue that negatively affects the value of the property. So again, buyer beware with this contract. They got to know all this stuff ahead of time. They're taking it subject to government statutes, ordinances, and regulations from a zoning perspective. This is if you're dealing with an LLC client, and wants to buy an investment property, right? You're buying in the city of Columbia and it's a 4-bedroom house. This is great. I can get $1,000 a bedroom, right? Until you buy the property, you lease it out to 4 units, and then the police come knocking on the door and say, hey, you can't have more than 3 tenants in a house within the city of Columbia limits, right? There's a statute, there's a regulation on the books from almost 200 years ago that was the anti-brothel regulations in the city of Columbia. And we have not gotten woke enough yet to take that off of the books, I guess. So those are the type of situations that could come up that could affect your buyer for their intended use that you have to be aware of before you enter the contract, because they can't get out of the contract after they've signed it if these things come up. All right, which is why you've already hit the nail on the head. If there's any specific special use that you know of, if you're representing a buyer, you do want to make the contract contingent upon their ability to use it for that specific use. All right, what are we getting? A general warranty deed, a limited warranty deed, or a quitclaim deed? This requires a general warranty deed. Okay, everybody understand the difference between general, limited, and quitclaims?
Let's go over it again.
Oh, Lord, all right.
Okay, never mind.
No, that's all right. Quickly, general warranty deed. I'm giving a property to Tracy. I'm warranting to her. If I'm a general warranty deed, there's no title defects anywhere in the history of the property. A limited warranty deed, I'm giving to Tracy. I'm telling her there's no title defects that have occurred during my ownership. Quitclaim deed, I'm gonna give her a quitclaim deed for the property, and I'm not warranting anything to her at all. I'm not even warranting to her that I own the property, but if I do, whatever I have, I'm giving to her.
And to be careful if you have buyers that are buying auction properties, because that's usually, it's one of those last two.
If you have a contract that the seller is not going to give anything but a quitclaim deed, you got a problem typically, right? Because that's either been bought through a tax sale or some kind of foreclosure issue, or there's some red flag that the seller knows about, which is why they don't want to give any warranties with regards to title. Okay, now limited warranty deed, if you see that, you are going to see that more often, right? If it's an REO or if it's a big company that's, builders don't give general warranty deeds, and they give limited warranty deeds. The warranties really don't matter. Even if it's a quitclaim deed, it doesn't matter if you're satisfied with your title insurance policy. Okay, because now in reality, the deep pockets are with the insurance companies, right? So your warranty is with the insurance company. Before we had title insurance, this meant a great deal more, because if you got a quitclaim deed or a limited warranty deed and there was a title issue from 30 years ago or 20 years ago, there's nobody to sue. There's no recourse. But if it was a general warranty deed that you got, they're warranting to you, there's no defects in title anywhere, then you have the ability to sue the seller. You have recourse at that point. But now your recourse is against the title insurance. As long as you're comfortable with the title insurance, the type of deed really doesn't matter, because if there's a title issue, you're going to make a title insurance claim. We've already talked about names. Now this is interesting. The deed is to be delivered by 10 a.m. on the closing date. The deed shall be delivered to the closing attorney's designated place on or before the closing date, no later than 10 a.m. Right? Where is this coming from? Right? Now, no, they use this on the coast, right? And I would venture to say, well, here in this area, we generally have one attorney that represents both parties. So we've got the buyer and the seller in the room at the same time, right? Now, it's not the same in Myrtle Beach. It's not the same in Charleston. They use dual representation a lot more than they do in Myrtle Beach or in Hilton Head, right? Which this contract covers. So you've got separate attorneys. You got a buyer's attorney, you got a seller's attorney. And this is meant for that specific purpose, is that we're not going to be waiting our closing on you, seller attorney, not getting us your seller documents until 5 p.m. the day of closing, when we sign the documents at noon, right? So this is a provision in this contract for those specific situations where if there's separate representation, the seller's got to sign their stuff beforehand, and they've got to deliver it to the closing attorney's office by 10 a.m. on the day of closing, so that once the buyer's done, the closing's done. You're not waiting on the seller.
It's two separate closings, basically. The seller has their own with their own attorney, and the buyer has their own with their own.
Correct. More expensive for everybody, it takes more time.
You mentioned how this is a seller's contract. If it's not there, can the buyer say, just like it wasn't there at 5 o'clock?
It's open the door there. It's open the door there, right? Now, some of this is kind of silly because are you supposed to schedule all your closings before 10 a.m.? What happens if we're closing one, right? We're closing one here, we got the buyer and the seller, but it's a 3 o'clock closing. But deed hadn't been signed by 10 a.m. on the day of closing, right? So they didn't do a very good job in specifying what that 10 a.m. applies to. But I think that's what it's applying to, is in situations where you have a separate seller's counsel. Yeah.
I'm beginning to think that they didn't actually have a real estate closing attorney advise them when they wrote this. But let's ask, that what Joe just said there. Let's say the seller's attorney is the one that fails to deliver. Now the seller's the one that's in default of the contract. What kind of options would that create for a buyer? I mean, you would think they still want to close on the property.
Sure.
Maybe they weren't happy about something and the seller's
Exactly.
pushing them towards closing and the buyer says, oh, no, I got it now.
Well, I can tell you this, we have a Myrtle Beach office. We got 2 Charleston offices. In Myrtle Beach especially, we never get the deed before 10 a.m. Usually we close and we're sitting waiting to disperse because we don't have the seller documents.
I mean, from where I'm sitting, that's fine. In 99.999% of the instances, both parties still want to proceed with it.
Right.
Correct.
But where I'm looking at this from a broker.
Yeah, 100%.
standpoint is this creates a lot of liability.
100%.
That's horrible. It should at least be like 7 p.m. or something on that day.
Right.
So that
Why even
like,
put a time? Why not just leave it as a day because you.
right, exactly.
I don't
Exactly.
understand
So
why they
best
put these times.
practices, should they be telling their seller, we're closing on the 14th and the buyers will be closing on the 15th, that way all the paperwork is done. I mean, is that a best practice?
Pursuant to the terms of this contract, I would say yes.
Assuming you can figure out before you do the contract when they're actually closed.
Right.
Because like I just had one that closed.
Well, I mean, for instance, if the closing is for November 15th, right? You want to try to get your sellers in November 14th.
Right.
Even if it's the same attorney, really, I mean, because some of this is not practical in that all closings can't occur before 10 a.m. Right? But this seems to be making the seller do their work before the buyer does their portion of the closing.
I will say in like Charleston, we see it occasionally where people will like close. Like I just had one where like they closed the sellers like a week before ours was supposed to be.
Sure.
Did everything.
So they can sign their documents whenever.
Right.
And we actually do that here a lot more than we used to. Right? We don't have, sellers don't want to sit through a closing. And quite frankly, it's easier for us if we're only dealing at closing with the buyer, right? It takes less time. So we're seeing a lot more sellers coming in to sign their documents before closing here as well.
COVID helped with that too.
Well, true. Any other questions with regards to conveyance? Deed recording fees, deed stamps and recording charges are always negotiable. Okay, there's no statute that says the seller has to pay the deed fee or the deed stamps and the recording charges. However, this contract does have the seller paying for it. Yes.
I mean, we're talking about terminology here, but I'm looking at, my responsibility and stuff, and I got a buyer and he's signing this thing, and then that first part of the paragraph, all government statutes, ordinance, rules, permits, regulations and stuff. How do I advise my buyer of that? I mean, I'm a buyer's representative, so I'm his fiduciary.
I'll give you all of the municipal regulations for each of the jurisdictions that are in the.
Well, there's books.
No, I
10 feet tall.
I completely understand. I'm just telling you what's in the contract.
He can write in that contingency though. Just like I write in the pool contingency, he can write this contract is contingent on review of the HOA regulations, on review of the easement.
Well, I wouldn't even say review. I'd say the purchaser's
And
approval.
acceptance, approval.
Purchaser's approval.
Yeah.
Yeah.
I say if you got the buyer, don't lose this contract.
He has
Yeah, but there's going to be situations that come up where you may be forced to.
Tracy, what contract do we use?
CCRA.
Which is someone who uses both is a way better contract.
Right.
This one drives me insane every time I look at it.
I can't imagine explaining it.
All right, earnest money. All right. You got a bunch of blanks. All right, so again, we need your participation more in this. Is the earnest money being delivered with the offer? Is it date specific? Is it split amounts? There's got to be something that's delivered with the offer, but it doesn't all have to be delivered with the offer, right? So you could, this is set up to where you can give $100, check with $100 when you send the offer or once it's executed, and then you can be required at the end of the inspection period or 2 weeks later or 30 days later to put up an additional whatever, right? So yeah, again, I think the purpose is to give you more flexibility. Yes, sir.
If you submit money with an offer, who do you make it out to?
Well, the line that says the last blank in there, buyer and seller authorized blank as escrow agents deposit and hold and disperse the earnest money.
So it has to be made, that's really unclear to me, if you're including money with an offer.
Sure. So you got to look at it collectively, not just that blank. So if you fill out all of paragraph, all the blanks in paragraph 5, you will, whatever monies you are required to give would be given to the escrow agent, which is also included in that blank that's been negotiated.
What's that time frame? It's obviously not going to be included with the offer.
Sure.
Can you take it the next morning, 48 hours like we have?
I would say as soon as you have receipt of awareness by the broker.
So it's not included with the offer, that is it?
Well,
So how are we filling this out, David? So $1,000 earnest money is paid as follows: 0 accompanies this offer, and 1,000 will be paid by 6 p.m.
if I'm you guys, right, if I'm you guys, to keep it the standard, the way you're normally doing it, if it's $1,000 of earnest money, you're gonna put a total of $1,000 earnest money is paid as follows. $1,000 accompanies this offer, right? But when you make the offer, the buyer's in control of the closing attorney. So they're also going to fill out here, you're authorizing MGC as the escrow agent. So when you send in the offer, you're sending in a check for $1,000 made payable to MGC. Or
But it's not even that.
you don't want to give the check to them. You may want to make a copy of it, right? And just send it with the offer, because pursuant to the terms here, it does say earnest money is paid as follows, this much accompanies the offer. Or if you don't want to, you cross out that section. Okay, you cross out that section, and in the next section, you put $1,000 will be paid by 6 p.m. on whatever date. Okay, so you don't have to fill out that first section, but I will also tell you that you guys need to be mindful of your real estate regs too, right? What is it, 48 hours? Is that right?
2 business days.
Yeah, you got 2 business days to make sure that you're turning that stuff in, so you don't want to put that a week out. I think the reason why there's 2 blanks here is because, again, in other parts of the state, folks don't want to put up the entirety of the earnest money until the inspection period has expired. So you put up a little bit, you put a down payment down, and then the full earnest money would get paid at the expiration of the inspection period. So that's what happens in other areas, and I think that's why there's 2 blanks here, yes.
When Tracy just said 2 business days, was that the CCRA?
No, that's the South Carolina Real Estate Commission, right?
Yeah.
Yeah. So
Actually, I just ran across something that was taken out of that contract, and it's not true.
now there's a difference between
About the earnest money.
there's a difference between contractual obligations and what the Real Estate Commission is requiring for real estate agents. Right, so we're talking about 2 different things.
Okay, I'll just get with Tracy later about what I heard.
No, but you can put, I mean, we
There's
usually
nowhere that
put
says
within
48
2,
hours.
we usually put within 2 business days. You don't put 48 hours because if the contract's accepted on a Friday night,
Yeah.
no attorney's open on a Saturday and Sunday.
Right.
So never put 48 hours, always put 2 business days. But there's nothing to say that your buyer says, well, I can't get it for 3 business days because I want to bring it instead of wiring it. So you can put 3 business, there's nothing to say you can't put a different number. Standard is 2 business days.
All right, the earnest money is not delivered by the designated date that you put in here. The seller has the right to unilaterally terminate the contract by delivering written notice to the buyer. Now, that sounds pretty standard, right? But typically what we would see in a contract is if the seller had the right to terminate the contract, they'd have to do so within 5 days of that specific date. That language is not included here. So let's say you've got in here that you're going to turn in the earnest money 2 business days from now. But you don't deliver the earnest money for 3 business days, okay? And 3 weeks later, another offer comes in for the seller that's, $20,000 more than what you've got under contract. And they start snooping around looking for ways to get out of the contract. And they discover that, oh yeah, the escrow agent did not get the earnest money until 3 business days, not 2 business days. And the last sentence of paragraph 5 says that the earnest money is not delivered by the agreed upon date, the seller may terminate the contract by delivering notice of termination to the buyer. Doesn't say when, doesn't say if they do it immediately.
That's not in ours though, right?
Correct. I don't have that in front of me. Typically what you'd see is in that particular case, they'd have 5 days from the date that the earnest money had to be delivered to be able to terminate the contract. And I'm talking about if I'm drafting a commercial contract, that's what we would include.
But
I don't know the
they are-
specific provisions offhand, what's in the CCRA contract about that.
They are in breach of contract if it's not delivered within the time frame that's specified.
I
Same thing with the repairs in them. I'm so anal about those because my understanding is if those repairs aren't complete, like when you said, even if you rectify it, unless it's specified,
The buyer has the right to get out of the deal.
they can get out of the deal and get back their earnest money 2 days before.
100%.
If
And it's
they're-
just the opposite here, right? The seller could wait until 2 days before closing to terminate the contract if the earnest money wasn't delivered on time.
Right, but I'm wondering, under our contract, if they could get away with that, or if they'd have to sue for breach of contract.
I don't know, like I said, I don't have that contract right in front of me, so I don't know the specific provisions, but I'll look that up and I can email you the answer to that. I don't think the CCRA contract gives a time period either, quite frankly. They would be in breach of contract, so they may still have the
I
right
love
to,
it when the contract is specific, it's so fantastic.
well, yeah, not this one.
Well, there is some benefit to the way that this is worded too, because it does give you more avenues to negotiate.
100%, and that is one of the main
It's a lot more
benefits
flexible.
or pros to this contract. You're exactly right. A lot of these blanks, again, it gives you flexibility for deal specific situations, right? Now it's a pain in the butt sometimes for agents because we got to work harder, right? We got to, it's not just a streamlined contract, same contract, same contract, same contract. Every deal is going to be a little bit different. But in reality, every deal is a little bit different. And this gives a little bit more flexibility rather than having to cross out everything and change dates and all that kind of stuff that we would have to in the CCRA contract. So that is, we haven't said a lot of benefits of this contract over the CCRA contract, but that's one. Earnest money disputes. Escrow agent cannot release or disperse the earnest money without a release or order from the court, unless it's otherwise stated in a separate agreement, right? So this is actually contemplating a separate escrow agreement that the escrow agent may have you sign. Now, I know we have a separate escrow agreement at MGC. Sometimes it gets signed, sometimes it doesn't. Are there other closing attorneys or escrow agents that are requiring their own documents being signed, or are they just relying on the contract?
Some are.
It's
I know
somewhat-
Blair Cato does.
Yeah.
I think Gillis does, but they never have, no one ever has me sign the form, just saying.
Well, and that's
So I don't
quite frankly, we do our best, right? We have a separate escrow addendum, which we ask our clients to execute, that gives us the flexibility as the escrow agent to be able to get rid of the earnest money in situations where there is a clear breach of the contract. So rather than having to wait on a signed release, if the buyer doesn't show up to close and it's gone and nobody can get a hold of him and he's never going to sign a release, in reality, if I've got to go to the court and file an interpleader action, that $1,000 earnest money is now gone. It's gone. It's used up in court costs. So the agreement, that the addendum that we have prepared, if the buyers and sellers are willing to sign, it's for the benefit of both parties. If the buyer doesn't do the right thing or the seller doesn't do the right thing, and then somebody's just refusing to sign a release and they're clearly in breach of contract, then we have the authorization pursuant to our addendum to release the earnest money. Now, if there's any controversy whatsoever, I'm not trying to get sued. So if there's any controversy at all, then we would still wait on a written release or we'd file an interpleader action. But oftentimes that we see, there's, the times that we can't get rid of earnest money It's because somebody is just being stubborn and refusing to sign a release.
Don't you have an instructional video for agents to be able to present to their client on
Sure.
that escrow
Mhm.
agreement?
Right, and the biggest thing is, if you're the buyer and you're bringing this other escrow agent, the listing agreement is saying, no, this just says you're gonna give the money back to the buyer. Well, yes, it does say that, but it also says, I'm gonna give the money to the seller if the buyer doesn't show up to close, right? So it's for the benefit of both parties, and there is a video, we can go over that certainly more in the future with you guys, but that's what this contract is contemplating, which is why this has come up, is that there's a separate escrow agreement that's executed by the parties. Losing party, if it does have to go to interpleading, yes, ma'am.
I was just gonna ask about this thing here, I guess I was ahead of you, is that in ours?
But
That the losing party has to pay everybody?
yes, and it even goes a step farther. I think it has treble damages that are included in there as well. So the CCRA contract, I think, even goes farther and specifies, I think it's up to 3 times the amount of the earnest money. Does that sound
Yeah.
familiar? So it's a little bit tougher on folks that don't do the right thing if it has to go to interpleader. But, you know, again, you get a judgment for treble damages. How are you going to get, are you going to get that money? When you go to court, the judge is not asking the loser to give them a check or bring them cash so we can give it to the other party. All you got is a judgment. And now you got to go spend more money to try to enforce that judgment.
This
So-
is interesting. Party receiving the least amount of earnest money in the courts agrees to indemnify. So our CCRA one does, it just says the winner or the loser,
Right,
basically.
Right, which is essentially this, I think can be interpreted the same way. If one party is more right than the other, even if they're not, even if it's not all or nothing. If a judge says, all right, you take 250 and you take 750, the 250 has to pay all the court costs.
Yeah, I just haven't seen a judge, usually they're all or
They don't
nothing.
split it up. Yeah,
Yeah.
you're right about that. Any questions about earnest money disputes? All right, transaction costs. Paragraph 5, what are we talking about? What's included as the buyer's transaction costs? And I'll tell you, here's where this is going to be important, right? Obviously, you got to know what the buyer's paying, the seller's paying, but if the seller's paying a certain amount of money for buyer's transaction costs, which we may all be rusty in because that hasn't happened in the last year or so, right? But it's coming back in 2023, hopefully. Buyers will have a little bit more leverage. If they're paying for certain closing costs, you need to know what that allocation of money can go towards. Because it's not going to everything that's on the buyer side of the settlement statement. It's only going to what these transaction costs that are defined in the contract are. So any lender fees are included. Any prepaid recurring charges. What are prepaid recurring charges? We're talking about homeowners insurance. We're talking about mortgage insurance. We're talking about tax escrow deposits, right? So those are things that are going to be charges that will recur on an annual basis that are owed at closing because everybody puts deposits into their escrow account. So that's included as a buyer transaction cost. Discount points, which is, I think, going to be a big one in 2023 as well. Interim interest. Everybody know what interim interest is? Nobody's skipping a month from a mortgage payment perspective, right? So what is today? The second, right? So you close today, your first payment is not due until January the 1st. Okay, but you're not skipping December's payment. When you make January 1st payment, you're actually covering for the previous month. So January's payment covers December. Now you're not required to make a December payment to cover the rest of November, but you're going to pay November's interest as a closing cost at closing. And that's what we call interim interest, all right? That's why you see that the mortgage payment, the first mortgage payment is pushed out by a month, but it's not for free. You're just paying the interest for the month of closing at the closing. Non-recurring closing costs are included here, right? So that's pretty much a catch-all. So non-recurring closing costs could be virtually anything. So essentially anything that's going to be on the buyer side will be included. All right, that went off. Did I mess something up?
Oh, that TV, is that what went on?
The whole power went out.
Yeah, it sounded like the fan went off.
There's a remote
Is
effect.
it still on?
I keep stepping on it. That's probably my fault. think it's the power.
It's coming back on.
Is it? All right. Size 15s, get in the way. All right, I don't have to look at it, I can look at your sheet too. So as that's warming up, we're going over closing costs. Title review, buyer's attorney's fees are included, commissions. Why is that included in the buyer side? Because it specifically says commissions if the buyer is contractually obligated to pay. Okay, so it could be some situations. May need IT experts.
Yeah.
So you may have, we didn't see it really, well, I did see a couple of transactions actually in the last couple of years where the seller did not agree to pay the full commission. So if there's a separate agreement between the buyer and the seller, and the buyer agrees to pay for a certain amount of commission.
Between the buyer and the agent.
Correct.
You said buyer and seller. So if there's an agreement between the buyer and the agent that the agent is going to be compensated 3% and the seller is only willing to split 2.5.
Correct.
Right. You actually said between the buyer and the seller.
I got you. I'm sorry. If the buyer owes any commission at all, right, that's also a closing cost. So if there is seller paid closing costs that are being paid, it could also be applied to whatever that commission is. Inspections, appraisals, surveys, cost to obtain HOA are all buyer paid closing costs. Actually, I'm sorry, cost to obtain HOA information are not included as a buyer transaction cost. And that's a big difference between the CCRA contract and this contract, because it's allocated in the CCRA contract that the buyer has to pay for all of that stuff. It's not allocated in this contract who's paying for the estoppel fee, who's paying for the transfer fee, the HomeWise, the CAMs, the management fees that are owed for the HOA stuff. It's not allocated specifically in here. The paragraph below the transaction cost deals with who's going to be paying for that. And that's the next slide. So if you notice in paragraph 6, the second paragraph, all costs to obtain information from or pertaining to owners associations, private public transfer fees, costs similar to transfer fees, certificate of assessment, capital contributions, working capital fees, estoppel fees. This is some serious dough in some of these subdivisions, right? I mean, we could be talking about close to $1,000. This is allocated based off of whoever you're going to negotiate it. Whatever box is checked, whether it's the buyer, whether it's the seller. All right, that part seems simple, but let's read the last sentence. If no box is checked, these costs will be added to the seller's transaction costs. All right. So if you're a savvy buyer's agent, what are you going to do? Don't check a damn thing, right? But if you're a savvy seller's agent and you get a contract or an offer that doesn't have a box check, what are you going to do? You're going to check the buyer.
The problem is do you want this coming up right before closing? This is an issue because you neglected to check a box as the buyer's agent.
That's true. That's true. It could cause some friction, but it doesn't change the contractual obligation. Right? So push comes to shove, the seller may not like it, but the contract says they got to pay for it. So be aware with regards to HOA stuff, that box has to be checked. If it's not checked, it's the seller's responsibility.
That seems so shady.
Well, it is shady, but I can't tell you how many times that we get a contract, whether it's CCR or this one, and a box is not, a box that requires to be checked is not checked.
It better not be one of ours.
That's not all brokers are as thorough as you guys are, for sure.
But here's what happens. The agent has to know the contract. If you don't know your contract and the other agent doesn't check the box, guess who's paying that fee? Because the seller's gonna be looking at you.
Yeah.
And so it just basically preys on agents who don't know their contract.
100%.
That's why I'm here. I have to know this contract because I see everything.
So
And
you want to make,
it's not shady, it's people who don't know the contract.
so for those of you that are in this class, those of you guys that are watching the video, make sure in section 6, especially if you are the listing agent, you've got to make sure that box is checked. Now, your seller may agree through negotiation that they're going to pay for it, but in those circumstances, I would check the box that the seller is going to pay for it, again, to avoid any confusion, and you already had those discussions with your seller. Because you're right, you don't want to get to closing and the seller says, I didn't know I was going to pay for these. And then you go back frantically and look at the contract. What did the contract say? I can't remember. Oh, it wasn't checked.
And I didn't advise them.
And you didn't tell them that now this becomes your responsibility.
Now,
Right.
normally in our CCRA contract, that's a buyer's transaction cost.
That's a big
Just
difference.
FYI.
And if you're using CCRA, you won't have to worry about that because that's included in the definition of transaction costs. That's what we're going over right now. It is not included in the definition of a buyer's transaction cost in this contract. All right, now if we're talking about if the seller has agreed to pay buyer's transaction costs, again, the allocation that you're putting in here, you get to put the dollar amount that can only be attributable to whatever has been defined as a buyer transaction cost, which in reality, because of that recurring or non-recurring closing cost language, is basically anything that the buyer has to pay for at closing. All right, so you're not going to have it's not going to be very often where you have an argument that your seller paid closing cost allocation doesn't apply to a specific item that's on the settlement statement, because essentially everything that the buyer could have to pay for is included on in this definition. The only opportunity the seller could have to get some of that money back is if you say I'm gonna pay $10,000 in closing costs and there's only $7,000 in closing costs. Okay. But you guys do need to make sure that you're looking at this. I know sellers have not, or listing agents have not had to do that as well. Buyer's agents, if you're getting seller paid closing costs, if the contract says $10,000, and that's a lot, if the contract says $6,000, your buyer's expecting what?
$6,000.
$6,000. Now, if you look like the hero and you got the buyer to agree to $6,000, or the seller to agree to pay $6,000 in closing costs, and this is a cash deal, and you know damn well there's not going to be $6,000 in closing costs, who's going to come out with mud on their face? You guys, right? So you really want to make sure when we're calculating and looking at negotiating, what amounts am I asking for with a seller paid closing cost credit? You need to factor in what you got to have some idea of what the closing costs are going to be. What type of transaction is this? Okay, and certainly with rates the way they are, discount points is included as a buyer's transaction cost the same way it is in the CCRA contract. So you can certainly use them for those purposes to help deals get done with lower interest rates. They're going to be applied to non-allowable VA or FHA costs first, and then allowable fees. If the closing does not occur, the seller is not responsible for paying any of the buyer's closing costs, right? That seems simple. So last sentence of the third paragraph in section 6, if there is no closing, the buyer is responsible for the buyer's costs, the seller is responsible for the seller's costs, right? So when you're having the discussion about terminating a deal, and the deal originally included $6,000 for seller paid closing costs, which means that the appraisal hadn't been paid for, the survey hasn't been paid for, the inspections have been paid for. We were going to include it all on the settlement statement because the seller's paying for it with a closing cost credit. And the deal falls through and the buyer decides to terminate the deal. Your buyer needs to be aware before they terminate the deal that all of those fees that the seller agreed to pay were only if it closes. So now that survey you ordered, now that termite inspection or home inspection that you ordered, buyer, it's your responsibility to pay, okay? And they may not be aware of that when they come to you and say, I want to get out of the deal. That may change their tune. All right, finally, anybody need a break? I know we've been going at it a while. That was a big sigh. All right, let's take 5 minutes and we'll come back. What time is it? Because I know I got lunch coming at 12.
10 to 12.
Okay, all right. You guys want to? How about this? Let's keep pushing through. As soon as lunch gets here, we'll go grab lunch, and then we can. Oh, is it? All right. Well, if it's here, then let's do that. Why don't we grab lunch? Come on back, and then we'll finish up while you guys are eating.
And I'll grab the other contract.
Okay.
Are y'all's offices? I know you have one in North Florida.
I do right on Johnny Dodds. And then in Somerville, we are right on, almost right on the square.
I'm good.
We're right on Main Street. I'm sorry. Is there a,
You are. Well, because of his issues.
Yep. Sweet, so Norwich, so all of our locations are listed there. I got great, two guys that work down there now. Obviously, you do most of your stuff up here down there? Yeah.
That's okay.
But you live down there, Jones?
I do. Yeah, I moved down there about a year ago.
Gotcha.
One, you said the one-time payments on, you have to look at that, because that'll bring it down back. So one time it's on the office.
That's, the down payment would not be considered a closing cost. So you're right, I did say it would apply to basically anything that's on there, but the down payment doesn't actually show up as an itemized thing. It's going to be included in the lump sum that are required by agreement. So unfortunately, it wouldn't apply to the down payment, but virtually everything else would apply.
And then it's what, drivers, I might be misheard.
That's right.
You're talking about the subdividing solid. So you said you couldn't actually, unless it has its own tax item, you couldn't actually sell it.
Well, you're not, it is not going to have a separate tax item. Whether you do it correctly or not until the year after the plat. Okay, so if I'm subdividing 3 acres, I go to the county, I have a survey done, get the survey approved, I record the survey, that 1 acre is in existence, but it doesn't have a separate tax map number until next year's bill. All right, so for the purposes of the 2022 tax bill, if the whole 3 acres will have 1 tax bill, it won't be a separate bill for the other. We handle prorations differently. But the main thing is, that you need to be aware of, is that when you're putting stuff in a contract, make sure that the closing attorneys are aware that we're not finding. This is only a portion of the TMS number that you're listing there, the address that you're listing there. Because if all you do is put the address and the TMS number, closing attorneys are assuming that all 3 acres are being transferred. All right, thank you. Sure.
Do you think they actually had a closing attorney sitting down advising them when they wrote this one? You know, saying, hey, here's some loopholes, here's some gray area, here's some potential issues, or.
Well, you know, I love those guys, the realtor association, and then there are a lot of attorneys. I don't know how many of those guys closed to loan before.
Probably not too many.
Right. I mean, they
probably have a real estate background, but they're probably mostly trial attorneys, or if they came out of college, got a gig there, just looked away.
Right. That would be my guess. There are certain provisions where I think I see what they were trying to do, but the language is not
The
specific.
intent versus the language.
Right, it's not specific enough to nail down all the potential issues that the language is brought on.
Yeah, I guess we'll get to a due diligence fee. I think they put a due diligence fee in there.
Well, they have. So it used to be, you had 3 options. You could do as is, you could do it, have a due diligence.
The due diligence fee will be influenced by the market. If it's a seller's market, buyer's market, buyer's market, what you're gonna see there. What I hate about our CCRA contract, it is too buyer friendly. It is. And I tried to get them to change that.
It may change a little bit this year.
I actually pushed for a due diligence fee or something for the earnest money to be non-refundable if the buyer goes under contract and then backs out without doing inspections or something or repair them. Because I had so
I
many
fought for that for
instances-
years, but they wouldn't touch.
For so
The
many
free
years-
load? They wouldn't do anything about the free load?
I always said,
The
there should be
permit
a 3-day
creates,
lemon law. If within the first 3 days they back out for no reason at all, they don't get their earnest money back. Or they only get it back during the first 3
Right.
days. The rest of the 7 days, it has to be due.
That would be reasonable. That'd be reasonable. Half the earnest money.
And get cold feet, do it the first 3
there was a
days.
lot of people that submitted 2, 3, 4 offers, and then if they won their favorite, they would cancel the others. So, and I know there was times where, you know, I would be under contract for a couple of days and then they would cancel, or I'd be under contract, they'd ride it out for a week or 2, wait and see if they got someone else. And then they would cancel without ever doing inspections.
Right. It's just a waste
I
of time.
hired a file seller last year for that. It was a $350,000 listing. We went under contract 3 times in 17 days. All 3 buyers backed out without ever doing inspections. And then the seller, because it's gotta be someone's fault, they have to blame somebody.
Sure.
Like, well, you're my agent, why aren't you protecting me? I want you, he fired me, I mean, I could have tried to force him to stay in the agency, but what's the point?
I think your solution is, right now, in section 18,
Yeah.
5 offers on
you
every.
put something in that says, if the buyer terminates the contract during the inspection period, a termination fee of X number of dollars.
Yeah.
will be paid. So,
But we're moving out of that market now, so it's kind of.
right, that would have been useful a year ago.
So with the contract being so buyer friendly, I think it was fine when they wrote it. I was on the contract committee for 2 years, it was fine, but then when the market shifted, it's like, oh, we have some issues in here we didn't really know of when we were in the buyer's market.
Right, which could present additional problems when the market changes again, right? So, there's not,
That's why I like the due diligence fee, because the due diligence fee will be dictated by the market.
that part is true.
So,
Sometimes it'll be 0.
yeah, so the contract will be more flexible depending on the market you're in. And it's not a buyer slam, it's not a seller slam, it's a contract that's determined by the market. Correct. So I don't know, it's not perfect, but I felt it was better than what we had.
Well, this one's definitely more seller friendly, and I would agree, CCRA is more fire.
I'll be curious, North Carolina actually posed a question on the message board. I mean, it has more than North Carolina agents that have been in this year to say, they just get their opinion posted at this point. North Carolina agents, just like to do those. Since you've been, I don't know yet, I haven't come back on that message board. So I'll be curious.
What they think. I bet they're so used to it.
It's just new. This is very good, you're doing it.
Well, it's already slow down. There's a lot of difference when we have questions.
There's so much information to share. All the financing stuff, I'm more of like, you need a partner lender, just what you need to ask. Like, it's not just a, what is the contract, it's how to work the contract.
Right, I think that they should be 2 separate classes, one without.
That's about you.
You're right.
No, I'm not saying you can. Well, that's why you.
I think it's 2 separate classes. 4 hours is a lot.
Yeah, I give them 2 breaks in lunch.
You're better not.
That's okay, we'll see how long it actually ends up taking you though.
Well, I'm just trying to direct, like, I'm from up north, everything is accessible.
Right.
So buy or sell a boat sign.
Time period, yeah, time period's good back.
Right. That runs through the closing stuff.
Well, for this, I've done a couple of times before, things that are starting to change.
This is the one or the other?
I'm not a bit disappointed if it's worked.
You guys want? We're bringing it down, we still got a little bit.
Oh, now this one. I just was trying to clarify what you did. Yeah, okay.
What do you have, what do you? Yeah. I think
Tracy.
Yeah.
Renee, Royal told me that Eric Summers doesn't give his escrow money to like after his.
Say what, Renee, in your, what?
Renee's comment told me, and this is what I wanted David here. Renee told me that Eric Simons doesn't get his escrow until after inspections. And I was like, where'd that GA rule go? That's what I meant. I don't know what I said. Ernest,
Well, you said escrow. Well, if it's agreed upon by all parties, fine. It's just like a property disclosure. It's not required unless all
Yeah.
parties agree that there isn't gonna be.
I
one.
guess I just didn't realize it was not a rule of 2 business days.
Well, I think they beat you, I think they beat 48 hours or 2 business days to do everybody. But in reality,
It's not.
the real estate commission regs do not control the contractual obligation.
Okay. That's where I got.
I think what that is for is that if the escrow agent has, this is, you gotta remember.
And it's not written in
That went
CCRA.
in when agencies were still the escrow agent in a lot of circumstances.
Okay.
So I think what the intent of that was is that within 48 hours, you have to have that money deposited.
So that you're holding the house in your name, you have skin in the game.
Yeah. Okay.
So this is our new one. We're talking about honest money.
Yeah.
We have it, that will be the brokerage attorney.
The same information, should not delivered by the deadline, contract may be void if it's under option. And there's no,
And then down here, we're actually going into if the escrow is an attorney or brokerage, we add that.
Oh, cool.
interesting.
I like that.
But it's the same situation through that language that it is in this contract. If they don't turn in the notice money on time, the seller does not have to terminate the deal. They can terminate it whenever they want to. They can do it at the closing table.
I guess I'm gonna give you a counterpoint to that is you don't know exactly when the seller finds out. So if you're gonna put a date in there, you have to be based on when the seller found out, and then you're gonna have to figure out how you can prove when the seller.
Well, if you
found
put
out.
it, if you put language in there that says they can terminate the contract within 5 business days of the deadline,
How do you sweat?
then it's on, it's now the burden is on the seller
To verify,
To verify.
yeah, that's actually, yeah, that would actually be how you have to do it, which on our closing checklist, one of the things we got on there is verify earnest money. And receive.
And most agents are asking for it, and we always send an email once we get it that verifies that it's been deposited.
Looking at this though, that the state contract, probably one of the more surprising things to me is a room full of agents and attorneys sitting around working on this would allow the client's contact information to be in the contract, because I as an agent certainly would want that, because it opens the door for unethical behavior, because it makes it much easier for the seller or the listing agent to reach out to the buyer.
Sure.
And cut the buyer agent out.
Well, there's
It's
nothing,
kind of like the self-checkers in Walmart. When you have someone sitting there scanning stuff, this comes up, cool, everybody's gonna put their stuff on there and get scanned, but the self-scanners, it becomes a lot easier to, switch the labels or.
well, that's true too.
It just opens the door for that kind of behavior from people who otherwise might not do it.
Now, there's nothing illegal about not doing it, about a buyer and seller talking to each other. Right?
As long as they both are good with it, they can certainly do that.
And if that, like, if there would be something wrong if you as the listing agent contact the buyer.
Right.
But the seller can contact the buyer. There's nothing wrong with that.
And sometimes the seller or the buyer don't know those, so I would rather have that. If I'm the buyer's agent, listing agent, reach out, hey, the seller would like to have a direct
Sure,
conversation.
no, I
with the
get it.
buyer. Hey, buyer, the seller would like to talk to you. Would you like to speak to him directly?
I think what you do is you educate your client on it. If you have anything sent to you directly by the seller or by the buyer, make sure I've had a chance to look at it.
It's already bad enough dealing with the builders. The builders do everything they can at this point to cut
To
us
keep
out.
you
They
out.
don't tell us when inspections and walkthroughs are scheduled. I had a builder not tell me when a closing was scheduled one time.
Really?
My client didn't let me know. Probably an oversight, but I wasn't CC'd on the closing email.
Still, then, yeah.
And they closed it earlier than anticipated. And I guess my client
just assume that would know, or doesn't.
And I represent the owners, but I would agree with you that,
The only closing I've ever missed was because I didn't know it was closing, it was new construction, no one told me they.
that, yeah, well, if you don't know what the closing is, you're not gonna be there, I guess. All right, while you guys are eating, since we got a few more things to go over, let's go ahead and keep rolling. All right, dealing with the financing section of this. And as a glimmer of hope for you guys, the majority of what we're gonna talk about is at the front of the contract, not the back of the contract. So this will get a little bit speedier here as we move through it. Now, again, the overall theme here is this contract wants to give you options, right? Now, does that mean more work for you guys? Yes, it does, but it also means more flexibility for your clients, which we discussed. Same situation here in the financing contingency portion or the financing portion of this. You got a box. Is it contingent or is it not contingent? You guys are going to check that box. Make sure it's checked if your buyer's expecting it has a loan. I don't know of a situation other than a seller's market, right, where you would not check that a deal is contingent upon financing, right? Unless we're in a situation where the market is crazy like it has been the last couple of years. I would always advise a buyer's agent, unless you think it would affect your ability to get a deal done, to check the financing contingency if there's a loan involved. Is it a 30-year or a 15-year loan or some other type of financing? So you are required here to put in and check off what kind of loan is this contingent upon. Why is that important? Because it may change, right? You may initially check 15 years and they may decide they want to get a 30-year loan, right? And if they're not approved, and I probably got this backwards, they may check a 30-year loan and they try to get a 15-year loan. And they are not approved for a 15-year loan because of the increase in the monthly payment for a 15-year loan. Well, pursuant to the terms of this contract, it's not contingent upon their approval of a 15-year loan. It's contingent upon their approval of a 30-year loan. So they wouldn't be able to get out of the contract because they have a denial letter for a 15-year loan. There's a space here for the maximum percentage of the purchase price. Okay, so again, we're defining the terms of this contingency and we're limiting the contingency to a specific type of loan, 30-year, 15 or other, or a percentage of the purchase price. Okay, why is that important? Well, as a general, and know that this is a maximum of, right? So you can be below this percentage, but you can't be above the percentage that you're going to put into this plan, which means I don't know that I would put 100% in here all the time if you're putting a financing contingency, but I certainly would put 97.5. All right, unless you know it's a VA client, and you may want to consider putting 100% financing in here. All right, if you're using a financing contingency, because it doesn't have to be 100%. This is a maximum of 100%. All right, and that gives you more flexibility for your buyer to get an FHA loan or to get a conventional loan at 80% as well. Okay, yes, ma'am.
That may be true, but it looks really bad to a seller.
And again, some of this stuff is market dependent, right? But the point I'm trying to make is you want to guess high rather than guess low if we don't know what type of loan they're going to be getting, because it gives your buyer some flexibility in the type of loan that this contingency would cover.
If the seller would be willing to take it.
Correct. Because if you put, for instance, if you put 80% in here, and that was the intent originally to get a conventional loan, but the rates are better at FHA, and they apply for an FHA loan, and they get denied the FHA loan, this financing contingency does not cover an FHA loan. It would only cover a conventional loan, right? So that's why if the seller's willing to accept it, you want to guess high rather than guess low, because the financing contingency would cover anything below that amount, but it's not going to cover anything above that percentage. Now, when does the contingency expire? This is the big difference between this contract and the CCRA contract when we're talking about financing. The financing contingency does not expire until closing. Okay? So You may be sitting at the closing table. We've already discussed when closing occurs, when conveyance occurs, right? We may show up at closing and with a denial letter. The seller has already moved all their stuff out. They're ready to move. And the buyer still has the right to get out of the deal pursuant to the contingency language of this contract, because it does not expire until closing. Of course, with CCRA, unless this has changed, Tracy, we know it expires 5 business days prior to closing.
I
Right?
say the same, but where does it say who gets the earnest money back if it fails to close?
Well,
It says either party may terminate this contract by notice, but
It's contingent on financing, so that means the buyer gets it back.
correct. So you can sign a termination, and that's in order for the seller to be able to go sell. That's in order for the
yeah, but they probably should have put in buyer retains earnest money. I mean, probably
correct.
should have put that.
Correct,
so
but the
that-
buyers, I guess the point is not about earnest money, it's about breaching the contract. They would not be in breach of the contract if they showed up at the closing with a denial letter.
I copy the language from the CCRA for financing contingency and put that into every single state contract I get, because you've never seen that until you've seen a seller lose the earnest money.
And have already moved out all their stuff, ready to close, and maybe they're buying another house, yeah.
On our team that was not aware that financing contingency is not 5 days before like it is in ours. Oh, boy.
Yeah.
Not asking them for a 5-star review.
For sure, so you need to be aware of the difference here, or if you're using this contract, you need to have some kind of separate writing or have it in the contract that supersedes this paragraph that says the financing contingency expires 5 business days prior to closing. You don't put anything in there, they can show up at closing with a denial letter. Now, what does it all go on to? The buyer cannot, the buyer has to refrain from any contrary actions, right? What does that mean? My best guess is they can't do anything to screw up their loan. They go out and buy their furniture, or they buy a car, or do something else that anybody that's been in this business long enough is probably gonna have an idiot buyer do. That will take them out of being able to use this financing contingency. So the contingency expires or is not applicable if they're not approved because of something that they did.
I noticed they have lender may change, so you have to write in who the lender's gonna be.
And that's correct. So that is interesting here in that the language talks about being able to change lenders, but you have to notify the seller and must receive written permission from the seller if the closing date is going to change. Okay, so it only specifies that you got to get the seller's permission in order to change lenders if it changes the closing date. So if you're going to push back closing, understand that, and you're pushing back closing because you changed lenders, that the seller has to agree to allow you to change lenders. If not, you better be able to close by the specific closing date using the other lender. Yes.
Again, I came from a different area. We used to have like 5 days, application has to be made for loan within 3 days or 5 days of signing of the contract, and then approval within 10 days of that application or whatever. And if they don't have approval at that 10 days, then basically, their financing contingency is.
Sure. Well, and
That gives you a lot more time to get it back on the market.
we have that section in here, but there's no set dates, right? So if you're going through paragraph 7, it does say that buyer shall apply for financing by, and there's a blank. So you can put 3 days in there if you want to.
Right.
You can put 10 days in there if you want to. That gives you some flexibility as to when the buyer has to apply for the loan.
Right.
And then underneath that, it says, and shall deliver notice to seller of pre-final loan approval by a date that you choose as well. So if you wanted that to be 10 days, you wanted it to be 20 days, you wanted it to be 25 days, whatever you want, you have the flexibility to put in these time periods. But once they're in here, you got to comply with them in order for your client to be able to use the financing contingency. Because if they apply after this deadline, or they don't receive approval prior to this deadline, then they cannot get out of the deal because they're denied for the loan. Does that make sense? So you can use those same time periods, you just have to insert those time periods yourself. And Tracy's already pointed out, if the financing fails, right, and they can't get approved, then the buyer must give notice. And then either party has the right to terminate the contract, right? Because that gives them a little bit of flexibility as well. They may not want to terminate the contract. They may want to give them additional time. They may want to just move the closing date back in order to allow them to have a new lender try to get approval for them. But if the seller decides they want to get out of the deal and they want to move on and not give them time period, then the seller has the right to terminate the contract as well. Now, in both of these instances, provided the buyer has complied with the terms that are established in this financing paragraph, then the buyer would get the earnest money back because they're not in breach of contract. But it does give the seller the opportunity to get out of the contract or to stay in the contract based off of the market. If they think they are not going to wait around, they've got buyers that are willing to buy it and with no financing contingencies, as soon as they get that notice, they can terminate the contract and sign another contract with somebody else. Okay, now, for those of you that are sort of familiar with this contract before, very, very confusing. The worst part of this contract, I know you guys are saying there's a worst part of this contract. The worst part of this contract was there used to be 3 different selections that you could make with regards to inspections and repairs. One was a due diligence period. Excuse me. The second one is called the repair procedure. All right, and the repair procedure has been removed. But what that basically said is, I think I mentioned this to you earlier, it limited what the buyer could ask the seller to do with regards to repairs. Had to be structural, leaky roofs. There was an itemized list of things that the buyer could ask for the seller to repair pursuant to the inspections. And the seller still had the opportunity to say no, right? And the buyer could get out of the deal if the seller did not agree to do these specific items. But if you ask for anything other than those items, right? If you wanted the walls painted, that's not a thing, that's not an itemized repair that the seller's obligated to fix. So even if the seller said, no, I'm not going to paint the walls, the buyer didn't have the option to get out of the deal. They could ask for it, but the seller was under no obligation to do those repairs. And the buyer really didn't have the right to ask for those repairs to be done. So whether the seller agreed to it or not, the buyer still had to buy the property, right? Which was very, very confusing. And the good part about this is that that is no longer a part of this contract. Now, there is a due diligence period, okay? Which is good for us because it is somewhat similar to the structure that we have in the CCRA contract, right? We got 10 business days, then 5, then 2, then 2. There's a bunch of other stuff, right? So there's a bunch of time periods in the CCRA contract that we really got to make sure we're aware of. This one actually, from a time period perspective, makes it simpler, at least from a understanding perspective. Because what we're going to do in section 8 is you're going to put in here when the due diligence period expires, which is good because you can take into account market conditions, time of year, our inspectors available, right? So if it's a seller's market like it has been, they can give you a 3-day inspection period. If it's not, then the buyer may get away with a 20-day inspection. And part of this is left blank because all of us know that getting an inspection done in the middle of July sometimes can't be done in 10 days. Okay, hopefully you guys have the inside track on your own folks and can get stuff turned around, but sometimes that's not available. Sometimes you can't get everything done that you need to get done within 10 business days. So this gives you some flexibility in those busy seasons to be able to build in additional time without having to put up additional earnest money or any other concession in order to extend the due diligence period. So we got a little bit more flexibility there, but it is going to expire at 6 p.m. on whatever date that is, 6 p.m. Eastern time, all right? So make sure that you know that that 6 p.m. number is in there, or time period is in there. And again, what are we considering? What type of market are we in? What type of inspections are needed? And what type of year is it, right? So all of those are factors that need to go into making the negotiation of the due diligence time period. Now, here's the big difference, okay? We know that you got 10 business days in the CCRA contract just to do your inspections and to submit a repair request, right? That's what CCRA requires. Well, the due diligence period has a lot more finality in this contract because everything has to be done during the due diligence period. There is no 5-day negotiation. There is no 2 days and 2 days and whatever else the CCRA contract says. So during this time period, everything has to be done, including inspections, including delivering the repair requests and negotiating the repair requests. You got to give the seller opportunity to obtain repair estimates because they're going to want to look at that stuff to be able to determine whether or not they're going to agree to the repair requests. You're negotiating the repairs, you're executing the repair addendum, all during this time period. If the repair addendum has not been executed prior to 6 p.m. on the specific date, and you have not terminated the contract before that time period, then you are stuck purchasing this property as is, if you're the buyer.
So we need at least 15 business days on there if we want it to look like the CCRA contract.
Correct. Correct. If you can get it, right? And that's, it's gonna be market dependent.
Yeah.
Charleston.
What is normal in Charleston, like 2 weeks or?
Charleston?
I'd say over the last year, 50% of the contracts didn't have an inspection.
Oh,
Yeah,
you mean they just didn't do it?
I've had sellers try to negotiate us down for like 3 or 4 days.
3 or 4 days, yeah. Which basically means you're not getting inspections done. May give you a chance to walk through it or do, various visual inspections, but you're not going to be able to get everything done you need to get done. So again, this is all market dependent, but it does provide you the flexibility to choose whatever you need. And your guy doesn't have to, if he comes back and says you only get 4 days, and it's up to the buyer. If they're not comfortable with it, they don't have to agree to it. Yes.
Does this require professional inspection or can it just be like an additional walkthrough?
Getting there.
And
Good question. Good question. So the main thing you need to know about this is everything has to be done during the inspection period, including you're sending a notice of termination if you cannot come to an agreement on repairs. So you either have to have the repairs negotiated and a repair addendum executed, or you have to terminate the contract all during this time period. Otherwise, your buyer's stuck buying it as is. Now, if you don't respond, now you can if the seller comes back and says, I'm not going to do any repairs, your buyer may say, all right, that's all right, I'm gonna buy it as is, right? Great, then you move on. But if you don't respond by 6 p.m. on that deadline, your buyer's stuck having to buy it as is. Delivery of a repair request does not extend the due diligence period. All right, so if you're at the 11th hour and you're sending your repair request, you're stuck.
What if you've sent it and the seller hasn't responded by that time? You just need to send over a termination?
You better have terminated the deal.
Or extension.
Right.
Okay.
Now, one solution possibly, which may muddy the waters a little bit, is if you're stuck in that situation, you send a repair request. Let's say you had 3 days, right? Let's say you had a very small inspection period. You send a repair request and you send a notice of termination.
together, yeah.
And you tell them that, and here's our repair requests. If seller, if you're agreeable to these repair requests, then we have a deal. In the alternative, here's our norm. If you do not agree to these repair requests, then here's our notice of termination. Okay, so that's one possible solution. But hopefully the point I want you guys to remember is Everything has to be done beforehand. Okay, so don't wait until the date that you got in there, unless you are waiting on that date to send the notice of termination. And if you're doing it on the date, has to be before 6 p.m.
Puts a seller in a pinch too, though, because they don't have time to go get estimates to see what.
And it's not, exactly, it's not gonna get done, right? So if you wait, in reality, if you wait to send the repair request until that day, the seller's not gonna agree to anything because they're gonna know how much it's gonna cost.
So you may want to send it and a due diligence extension with it, instead of termination, maybe.
And you could do that too.
No way you can
Yep.
inspections done, have the seller not get estimates from my contractor, so that does these things.
If you do it, I've had to do this before, it's a long story, but it was the only choice that I had. And I told the agent, listen, I know this looks really pushy and I'm really sorry, but I have to protect my folks,
Sure.
you know? And it was because we had to have multiple inspections and it just ran up against the time. There were just a lot of complicated factors. But I think it frees everybody up from the due diligence when you do it that way. Because you can tell them, look, we can continue to negotiate. We can all agree on any variation of this. I'm not telling you, if you don't do all of this way right now today, that we're terminating, my people still want to buy this house. Do what you gotta do, get back to us. If it works, great, we'll proceed. If it doesn't, you've got our termination and we're protected.
And
We get back our earnest money.
And that's the reason why I said you said both of those.
Yeah,
Well, I would actually, wouldn't send all, I'd send 3. I'd send an extension.
Well, and that's what Tracy said too, right?
Yeah.
You can also send along with that an amendment to the contract, which extends the inspection.
problem is they have to sign the extension, like in my case, the sellers were overseas. And so I knew there was a time lag between when they were gonna get
Sure.
the extension and be able to get it back to me.
Yeah, yeah. If you're gonna send the extension, you also want to send the termination letter. So like you said, if you're stuck in that position, you probably want to send all 3 just to cover yourself.
Yeah, because it's not extended until the people sign, they can. sign
Right.
it. So that was my situation, that's why I had to deliver the termination at the same time.
Well, and I think you were smart for covering yourself. Even if the deal actually came to fruition, you at least protected your client if the seller wasn't gonna agree to
Well,
do it.
you're right to say I'm covering myself, because guess who's paying the earnest money?
Right.
I don't do that,
Right.
right?
Now, I will tell you, I don't think that's the intent of this paragraph. The
Right.
intent of this paragraph is to have everything done during the inspection period. Now, in order to do that, yep, go ahead. In order to terminate, okay, you got to deliver the repair request and have everything negotiated if you're going that route. But in order to terminate the contract, if it has not worked out, you have to send a notice of termination. Now, remember, the next to last document in this contract is the South Carolina Realtor Form Notice of Termination. Language matches the contract. The main body of the contract is expecting this form to be used if you're terminating. Now, what is a notice of termination and what is required? It's a unilateral communication. Okay, so the notice of termination does not have to be signed by the other party. All you're doing is sending them a document that says we are terminating the contract, okay? In order to make sure that you're meeting your requirements of the deadline set through the inspection period. But that's not it, okay? You have to send a notice of termination and you have to pay the termination fee, which is indicated in the contract together with the notice of termination. If you just send the notice of termination, you have not terminated the contract. You have to send it along with a tender of the termination fee.
Well, if you put 0 for the termination fee,
Then you don't have to pay anything. But you would not have gotten away with that in the last couple of years.
right, but, well, I mean, everyone around here gets away with it because we don't have it in the necessary
Right.
contract. So if there is a 0 termination fee, then would the notice of termination be fine unilateral like it is?
Correct.
Okay.
That is exactly right. So,
Just for reference, because I'm on a message board with a lot of North Carolina agents who've had a due diligence for a long time. The past year and a half, their average due diligence is $5,000 to $15,000 because of the market. That was what the buyers had to put down at least that much for the seller to take their offer.
yeah, just to even get the contract.
Yeah, so they were, whether they bought the house or not, they were gonna be out on average $5,000 to $15,000.
I mean, I've heard of sellers, they went through 3 contracts right? They had a crappy piece of property.
Yeah.
But there wasn't anything else available. People kept putting it under contract and they kept agreeing to pay this termination fee. You know, they made 15 grand in 2 months, didn't sell the property, still got the property to sell.
It's crazy.
All because of the market, which is why we got the first bullet point up here, right? That termination fee is 100% negotiable in this contract. So it's gonna be heavily dependent on who has got the leverage in the deal. Can be zero, right? And if it is zero, it is just like the CCRA contract from that perspective, because the buyer has a free look, right? They don't even, and much to Brandon's chagrin, they don't even have to do an inspection. They've got whatever that time period is to terminate the contract, and they do not, and they get their earnest money back. The seller doesn't get anything for taking their property off the market. Somebody have a question? I see. Okay.
Seems strange as heck.
Say it again.
That seems strange as heck, you know, they're putting up $5,000 or $10,000 and they go and do the inspection and they find busted foundation, the leaky roof, but this and that.
You're out
you know,
$5 grand.
You're out the money.
Again, it is market dependent. I can tell you from personal experience, I've heard several contracts in Charleston where we didn't have termination fee
Right.
at all. Like in Ladstone or out in Hollywood, SC.
Right,
No one cares about that.
right.
So, I mean, if you're about selling a house in downtown Charleston, Mount Pleasant, expect a 5 to 10. But if you're in like Ladstone, Somerville, Goose Creek, those areas, no one cares about it.
And again, you know, be cognizant of the fact that if the property has been under contract before, look at the property disclosure, because if there were those problems, they should have updated it. If the property disclosure has not been updated at all, then ask the listing agent, do you have the updated property disclosure? Because there were probably inspections and they should have updated it. If you're working with a crappy agent who doesn't know any better, they're not getting them to update the property disclosure.
And that could
before
give you an
put
indication
$5,000
before your
in.
client agrees to sign a $5,000 termination fee. If they're going into this knowing that there's significant repairs that need to be completed, and the chances are unlikely that the seller is going to agree to repair these things, then you don't want to agree to a $5,000 termination fee, because the chances of this deal working out are not very high.
Or ask for the inspection reports.
Right.
The old inspection reports.
Right.
The flip side of what you said, Tracy, though, in a seller's market, that seller's got 10 other offers. You're just not gonna sell to your buyer. They're gonna go somewhere else. It's easier to deal with.
No, but it's free for you to look for the proper disclosure and see if it's been updated or not, and warn your client this could happen. So as long as you're disclosing to your client that, hey, there could be a change that they haven't made.
I mean, in theory, you're right. I agree with you 100%. In real life, there are sellers and agents that are going to just say, hey, this person's asking a lot of questions. Let's just put them to the side if you've got other offers to pick from.
True.
Well,
Again,
I'm telling my buyers-
again, market dependent,
Yeah,
but you got to protect your buyer too, so.
Yeah.
Now, one that you mentioned, inspection reports or complete inspection reports. As I'm sure we all know, CCRA contract, when you turn in your repair request, you've got to submit entire copies of all of your inspections. Right, that's one thing I didn't mention. In the due diligence period, when you give your repair request, you do not have to give all of the reports. It specifically says all or portions of the report. So the only thing that you have to give with the repair request is whatever specific portions of the inspections that deal with your repair requests. So that's another change between this and the CCRA. Now, the other thing I want to impress upon you guys is can't terminate unless you deliver the notice and the money. So if it's 5 p.m. on your deadline, how are you gonna get them the money? Venmo, wire? No, I mean, I could potentially see that being a problem, right? And I don't know about in reality, but if the earnest money is $5,000 and the termination fee is $1,000, okay? You turn in the notice of termination, but you don't deliver the termination fee until the next day. Well, I'm saying no, thank you. You haven't terminated the contract. I'm not taking your $1,000 termination fee. I'm taking the $5,000 in earnest money because you have not terminated the contract prior to the due diligence period.
You could put language in there that said termination fee, if relevant, will be deducted from the earnest money.
That's the hot button issue right now, how to deal with the termination fee. It is contemplated in this contract that the termination fee is separate than the earnest money. Separate than the earnest money, does not need to be paid when the contract is signed, does not need to be tendered, it's not held in trust. It just has to be delivered to the seller prior to the expiration of the inspection period. So the argument for that would be, in reality, that makes way more sense, right? If the termination fee is $1,000, the earnest money is $5,000, then you take $1,000 out of the earnest money and the seller gets that. But there has been problems since June, since this has come out statewide, and that most of the attorneys, closing attorneys or the escrow agents are taking the stance that these are totally separate fees. You cannot pull it out of the escrow agreement. Now, one way that I would be willing to do it is if the release was also sent at the same time, which it should be, and it authorizes the escrow agent to pay the termination fee to the seller out of the earnest money. All right, so you got two documents at the back of this. You got the notice of termination and you got the release. These are two separate things, right? Notice of termination is unilateral. Nobody's got to agree. All I'm doing is giving you notice that I'm getting out of the contract. But in addition to that, you got to be able to tender the termination fee, which means you either have to hand it to them, you either have to wire it to them, they have to have that money prior to the expiration of the due diligence period in order for your termination to be valid, in order for you to be able to get your earnest money back. Now, what you may do is to send a notice of termination and to send a release, which will need to be executed by both parties, right? Notice of termination is just signed by the buyer. The release needs to be signed by the buyer and the seller. And if that release authorizes the escrow agent to pay and tender the earnest or the termination fee out of the earnest money, then I think you're covered, all right? Because they've agreed to accept it later, okay? But both of those things have to be executed by, or the release has to be executed by both parties prior to the expiration of the due diligence period.
So it seems like the sellers could just refuse to sign.
They could.
the earnest money.
Which means you may be stuck having to make sure that they have the money in their hand, which means you don't need to be dealing with this on the last day of the inspection period. Okay,
Money in their hand, can you give it to their broker?
I think that would work. I think that would work. So yes, it is the specific question as to where does the termination fee come from and when is it delivered? Those are the hot button issues right now. All I can tell you is what the words in this contract say right now.
What kind of receipt are we showing for handing it to them?
Yeah, sure, good point. If you're wiring it to them, obviously you're gonna have some kind of confirmation. But if you're gonna hand money, you at least need an email confirmation that says the money has been received. Yes.
So are you saying that in the contract, you couldn't say buyer and seller agree that termination fee, if any, would be withdrawn and subtracted from earnest money?
Could you do that on like a separate addendum?
Because I just don't see this whole chasing people down. Like, I can avoid service. I can just be gone and vanish. And now my sellers are getting the earnest money, all of it.
Yeah.
You know, if I'm unscrupulous, I can just like not answer my phone. They don't know where I live.
Sure.
You know what I mean?
Um,
It's so shady.
Maybe. I mean, it's not a bad idea. And
I think it's a horrible idea.
hasn't
I'm
been
just saying.
hasn't been litigated. So I can't tell you what a judge would say about that. All I can tell you is that closing attorneys right now, since they changed this, have been very adamant that unless there is a signed writing, and the contract would be a signed writing by both parties, we are not giving you any part of this earnest money because I'm not authorized to give you any part of this earnest money simply with the notice of termination. If the contract says something different, or if the release says something different, that's been agreed upon by both parties. And that's what the big difference I want you guys to understand between the notice of termination and the release. One is signed by one party, the other one is an agreement signed by both parties. What do? The release releases the contract in its entirety. Buyer can't sue the seller, seller can't sue the buyer. It also tells the escrow agent where to give the money. All right, this is a separate form, Form 313, which you guys have, it's unilateral, signed by the buyer only, must be accompanied with the termination fee.
Why wouldn't they have put the broker signature spot on the release? What, that's the bane of my existence right now. Why wouldn't they do that? It's a release of a contract. The contract involves Keller Williams. I just don't get that.
Well, yes and no. I mean, the contract's between the buyer and the seller. I do think, even though it's the Realtor Association, I think the CCRA contract has a lot more provisions that are there for protection for agents than the actual Realtor contract does.
Yes.
Termination fees not in the earnest money, separate forms. That's what we've been talking about. Now, the release has to be signed by both parties. And it is to release the earnest money, not the termination fee. Those are separate under the contract unless the contract says differently. Would send along with a notice of termination and termination fee. And again, the reason why you probably want to send the release, all right, let's say I'm 48 hours prior to the expiration of the due diligence period. I want to send the release with the notice of termination and the termination fee if you're sending it. Because as a seller, I'm going to be more, even if I'm unhappy about you pulling out of the deal, I'm going to be more apt to sign this release if I'm getting some money, right? So once you're terminating, I would send the release immediately. Let's not give the seller time to think about the opportunity to contest the rest of the earnest money. I would send both of those things together during the due diligence period with enough time to have that release executed by the other party. Yeah.
So then now that goes back to our other repair agreement. We're sending the repair agreement on a short-term notice, so we're gonna send a termination agreement with it to cover ourselves. And then we're sending the termination fee with that, and then we're
And a
sending
release.
the release with it.
Yeah, just send them a book. I understand.
This was drawn up by lawyers, wasn't it?
Must be smart attorneys, not this guy. I'm just here left like you guys are to deal with the mess that it's. Yeah, don't shoot the messenger. I'm just telling you what's in it, guys. All right, inspections, final inspections. You've already asked about this with regards to who has to do inspections. Now, it can be the buyer. So the buyer can do their own inspections if they want to. But anybody else that's doing inspections has to be licensed and insured.
Brother,
If he's licensed and insured. Brother's not the buyer.
but the brother could walk through with the buyer.
In reality, that would be fine. But the contract says the buyer or licensed and insured inspectors are the only ones that have the right to do inspections.
Something else I used to write in the contract was subject to satisfactory homeowner policy quotation, quote, coverage or whatever.
Not bad. For a buyer, any contingency is good. It must be non-destructive examinations, right? So you can't put holes in the walls or the dirt. You gotta provide reasonable notice to the seller that you're going to be doing inspections, right? And what is reasonable notice? Is that 3 hours? Is that a day? Who knows? That's kind of open up for interpretation. The point is, you can't just show up. You got to tell the seller you're coming. It specifically includes language that the seller will grant the right to perform any walkthroughs within 48 hours of the closing date. Okay, so the seller is contractually required to allow the buyer to do a final walkthrough. Seller has to keep the utilities on unless they've agreed otherwise to do so. Okay, and there's a real interesting box that's included here at the bottom of paragraph 9 that you can check. It says the seller grants buyer permission to connect the utilities, pay for the utilities, and hire professionals to safely connect and operate the utilities during the inspections. So I guess when you're dealing with an REO or, folks that generally speaking have already turned everything off, the seller can check this box if we're using this contract, and the seller's not going to do it for you, but that at least authorizes the buyer to be able to do that, mainly because the clock's ticking, right? We don't want to have to wait on our inspections if we've got a set due diligence period here to turn the utilities on, because that may not give us enough time to do what we need to do. So that would be an appropriate box to check. It's more work for the buyer or you as their agent, to have to go out and do this, but it could save you some time and waiting on the seller to do it. Appraised value, much like the financing contingency, we got a box. Is this going to be contingent upon appraisal or not? I know we've all been through the gamuts with appraisal and gap contingencies here over the course of the last year or two. Hopefully we don't have to be as creative as we have had to be here in the last couple of years. However, if the property doesn't appraise, the buyer does have to tell the seller that it hadn't appraised. At that point, once the seller has received notice that it hasn't appraised, the seller has 5 calendar days or closing, if this happens 2 days before closing, whichever is the earlier time period, right? So if we're 10 days before closing and we get the appraisal back, it doesn't appraise, and we deliver notice, the seller has 5 days from that point, all right? If we're 4 days from closing and we tell them that it didn't appraise, the seller now has through closing, even though that's not 5 days, they've got the 4 days before closing in order to decide whether or not they want to proceed to closing at the appraised value, or if they want to terminate the contract. Now, they also, if they refuse to reduce the purchase price to the appraised value, the buyer can agree to go ahead and buy it at whatever the purchase price is in the contract, even though it didn't appraise, or the buyer has the right to terminate the contract. You need to pick one of the options, all right? And you should always try the first option first, right? I mean, you should always decide that, hey, let's try to get this at the lower price rather than the original purchase price if you can. And that way your buyer may be able to save a little bit of money. Yes.
What about other appraisal issues, not only the dollar amount, but if there's a health, safety, or an inspection issue with the appraisal?
Excuse me. Got all these questions. This only talks about the value, right? So this only deals with the value of the property, and I certainly understand your point. If this is a VA inspection and repairs are required, what are we doing with that? Well, if it's a VA loan, which most of those are going to show up, or if it's an FHA loan, there's also that escape clause. There's also that amendatory clause with FHA loan, right? Which says if it doesn't appraise, then they automatically have the right to back out of the deal. So I think the buyer is covered through those ancillary loan applications to the contract, because this does not cover that situation.
Could be in that repair
Correct.
area too.
Right, and if it's after the inspection period, the buyer would have to rely on the escape clause or the amendatory clause to be able to get out of the contract.
Okay. Question about that. If it's subject to, though, it's the value of the house is subject to those repairs, so wouldn't it technically not have a price anyway?
Correct, that's right.
So
I mean,
either fix it, reduce the price, or move on at that point, right?
yeah, did you get through your first 2 years of law school? It's a pretty good argument. It's a pretty good argument. Yes. So, I mean, but again, it's an argument, right?
Right.
It's not clearly stated in here, but that's a perfectly reasonable stance. If you're on the buyer side, is that, yeah, this did not appraise for this purchase price, or it doesn't appraise for this purchase price until these repairs have been completed. So that's another argument in addition to the amendatory or escape clauses. Yep.
Would that termination fee still be in place, except pay something to get out of it if it doesn't appraise?
See, the termination fee would be different because the appraisal contingency is separate than the due diligence rights. The financing contingency is separate than the due diligence rights. So you don't need to provide your notice of termination unless the seller does not agree to sell the property to you at the lower purchase price, right? Because once you deliver notice, the seller can agree to, yes, I'm going to agree to reduce the purchase price, or no, I'm not going to agree to reduce the purchase price. And then it's on the buyer to decide, am I comfortable buying it for a purchase price it didn't appraise for, or do I want to terminate the deal? And if they decide to terminate the deal, then they send a notice of termination, okay, which is a unilateral communication along with the release, but that's different, and it does not have to be done during the due diligence period because the appraisal and financing contingencies are separate from the due diligence stuff. okay? Also separate, perfect segue, is the termite inspection, right? So we talked about all those inspections you had to do in the due diligence period, doesn't include the termite. Termite has its own separate section in paragraph 11. And it's not separate in the CCRA, right? Termite inspections are inspections with the CCRA contract. Now you get to pick a bunch of things here. Again, on the flexibility option, I'm already stretched out by this contract. But you do need to be aware that this is a separate thing, and you're going to choose a couple of things. Number one, whether or not the sale is contingent upon a clear CL 100. Okay, so if you're the buyer, you want it to be yes. If you're the seller, you want it to be no. Market dependent, all that kind of stuff that we've talked about. You also get to choose who's paying for it. You also get to choose who's selecting the inspector. And these don't have to be the same boxes, right? So it may be contingent, the seller may be paying for it, but the buyer may be choosing the inspector. All right, so all of those things give you some flexibility as well to help negotiate the deal. Now, some important things to remember: how long do you have to provide the CL 100? Right, you get to choose that. That's why we got a blank in here. When does it have to be delivered? Okay, and that's up to whatever box got checked. Is the buyer getting it? Is the seller getting it? But whoever's getting it has to provide the clear CL 100 within that time period that you are going to put in here. Obviously, it must be dated no later or no earlier than 30 days prior to the closing, because that makes them ineffective. If it's the buyer's obligation to provide it, and you don't provide it during the reference time frame, then the contingency expires. Okay, the buyer does not have the right to get out of the deal, even if the CL 100 report had repairs that were recommended.
So this isn't subject to due diligence?
It is not. This is totally separate. Totally separate.
For VA loans, the seller always pays, right?
Not anymore.
Right. Now, you can change that. You just check the seller box.
I mean, so the problem is, if they go in and say, okay, 15 days before closing, provide it, what if there are repairs that are needed because of the termite inspection? You just gotta hope that the home inspector sees it?
No. Because here, let's keep
Because then you
going.
can't ask for it.
No, you can.
Because it's.
So what's going to happen is when you get the CL 100, if you're the buyer that got it, you're going to give it to the seller. The seller is required to repair the recommendations or to provide a clear CL 100 letter.
Oh, that's paragraph 2 then.
Okay. So again, this is totally separate. You're right, but it does contemplate that this timeline is going to be after the expiration of the due diligence period. So if the buyer goes and orders the inspection, it comes back dirty, you give it to the seller. Seller can then decide to do the repairs, or, and this is where it may get a little bit shady. Seller gets their buddy to issue a clear CL 100, and technically that checks off the requirements of the seller. Now, that also opens up buddy, if they're not issuing CL 100s correctly, to liability to the purchaser if there is damage. But that is one thing I don't like about this provision, is that they're not required to remedy the repairs or remedy the issues. They can do that if they choose to, or they can provide a clear CL 100. And that has to be issued on or before the closing date. So it can be all the way to closing before you get that taken care of. Yes, sir.
So the termite inspector comes in and says, hey, you got this, that, it's gonna be $6,000 to make these repairs, treat the property, this and that. The seller says, no, I'm not paying it.
Not allowed.
So he is bound no matter what.
Correct. Hang on.
So they say, okay, we got beams, we got floor joists, we got floorboards, all terminate, all need to be replaced. It's $19,000.
No, you can terminate.
It's a contingency. It's a contingency.
Okay, so the seller does have the right to say, no, I'm not
yes,
making.
but if the seller does not do it, then the buyer has the right to get out of the deal.
Right, okay. Yeah, okay.
So I'm sorry, I misspoke about
Okay,
that.
yeah, no problem.
If the seller does not make the repairs of the treatment, the buyer then has the option to accept the property in its current condition, negotiate for payment of the repairs or a portion thereof, or they can terminate the contract.
Now, would they have to get the clear CL 100 from, say, the buyer was picking the inspector? Do they have to get the clear CL 100 from the buyer's inspector, or they can just say, these are the
Doesn't- it doesn't-
recommendations and somebody else?
Doesn't say, and that's why I said that may be the shady way out, right? They may
It
have
says
somebody that's.
workmanlike manner.
Right. So there are issues with this for sure. But the point of the difference between the two contracts is this does not have to be done in the due diligence period. It doesn't have to be done at all if the is contingent box is not checked, right? And what this is doing is is allowing the buyer another opportunity to get out of the deal if the termite inspection reveals damage that the seller is unwilling to do. Okay? Yes.
If you do have the clear CO 100 and the closing is delayed, and it's no longer within 30 days, who's responsible for getting and paying for the next CO 100 to be?
I'd say whoever's checked off.
Is
Who-
that or
whoever's check-
whoever delayed the close, whoever's fault it was delayed?
That's not what this says, right? This says, this says if the buyer's box is checked, it says they should timely deliver a CO 100 wood infestation report dated no earlier than 30 calendar days prior to closing. So I think it depends on who's checked box.
Well, it's something you negotiate when you're doing the extension, right? So that may say the buyer, but the buyer can say, hey, listen, we're happy to extend, we'd love to extend, we're only gonna do that if the seller provides the CL 100. If it's the seller's fault that the whole thing's happening.
Sure, that's one way to get around it.
You need a whole addendum to this contract.
I do think I've submitted an offer with this contract without it. At least one of them.
Well, and if you go, we'll get there in a second, but they list out all of the different forms that are available for the Realtor Association.
I will say, I actually really like that part of this contract, because then you know what to look for.
It makes it easy, you're right.
There's no surprise.
I mean, it's not bad. I mean, they're referenced better, correct? All right, any other questions about termite stuff? If it's new construction, well, and here's the other important part about this. The last sentence says, seller's obligations end at closing. Okay. Repairs end at closing. Which means if you don't have your reinspection done after the seller's repairs are done and you don't object, then if you're at 24 hours after closing and you figure out that they really didn't do it, that means you've lost the right to sue them as well if you don't confirm that those repairs have been done to your satisfaction prior to closing, because their obligations end at closing.
That sellers love out-of-state buyers.
Yeah, for sure. If it's new construction, their builders are required to treat their property for the prevention of termites. So there'll always be a soil treatment letter that are included and is required pursuant to this contract as well. And the other thing to remember is that this is outside the due diligence period, which we've indicated before. All right, broker recommendations, paragraph 12. All of this stuff is actually in here for your benefit. This is, you guys may already be getting one of these done or signed recommending that all these things be done. Well, they've helped everybody out and put it in paragraph 12 that you as the agents have already recommended that the buyer do all this stuff. Survival, if any part of the contract is to be completed post-closing, then those terms survive closing and are still legally binding, okay? But with regards to the termite stuff that we talked about, all those repairs are supposed to be done prior to closing, okay? So if for some reason, and it may be a cash deal that's involved with this, lenders won't go for this, but if there's repairs that need to be done after closing, then that provision of the contract, if it's been agreed to be done post-closing, survives the closing.
Best examples like a broken window.
Correct, correct. So if there's a signed addendum that says, we're waiting on the East Glass for the product to come in, and they're waiting on it to be shipped, and that will be installed as soon as it comes in after closing, then that contractual obligation extends and survives closing. If it's not in writing, it does not survive the closing. Yes.
And then with that, would you maybe have funds held in escrow to see that this stuff gets paid for?
I'd love to have me hold some money out. Yes, sounds great. It's more work for the closing attorneys. And we're willing to do it in some situations. Most of the time, I'll tell you how we handle it. Because the last thing I wanted to get involved in is an argument about whether or not it got installed correctly. And meanwhile, my accountants are yelling at me every week, get this money out of our account, get this money out of our account. And I don't want to have to file an interpleader action to figure out this argument, right? So most of the time, what we'll do is we know what the amount is. We know how much the window costs. So we're going to make a check, or take a check from the seller, collect the money from the seller, made payable to Ace Glass. I'm going to give the check to the buyer at closing, already made payable to the contractor. Once that work's done, they got the money to pay for it. So that in most instances is a more efficient way to handle those type situations. Now, if we're in a situation where we don't know how much it's going to cost, that is a special situation that may require an amount to be escrowed because we don't want to cut a check that's going to be short for the amount that's owed. But pursuant to the survival paragraph, getting back to the contract, even if we didn't escrow, the seller is still contractually on the hook for that because it was agreed to in the contract to be completed post-closing.
Yeah, but if you move to California, yeah,
True.
good luck.
True. All right, home warranty, another group here that allows you guys to choose what's going on. Who's ordering it? You guys choose. You gotta have it, it's gonna be for at least 12 months of coverage. The specific dollar amounts, you're gonna put who's paying, right? So this is not just about the seller. It's going to put who is paying for the home warranty. Also says, notice that the brokers may receive compensation from the warranty company for referrals. That's to keep you guys out of trouble for whoever is still participating in those. I'm assuming there's no question about that warranties. One item as a closing attorney, guys, if it's the buyer's responsibility to order the home warranty, and if you are representing the buyer, please order the home warranty and provide the confirmation to the closing attorney, simply because we cannot send a check to the home warranty company without the confirmation, because there's nothing to apply that money to. So if you're putting in your contract that you're responsible, make sure we get that sent to the closing attorney. Now, if it's not your responsibility, we'll go bug the listing agent or whoever the other agent is that's involved, whose responsibility it was. But it does cause us issues at closing if you have not ordered the home warranty and we don't have that confirmation notice.
I mean, if you're ordering it on behalf of the buyer, are you gonna write your name in it?
Who?
If the agent is ordering it on behalf of the buyer.
I think you put the buyer's name in there.
Okay.
And I've never done
What
it
do you mean
before.
on here, agree that home
Oh, I
warranty
thought you meant when
by,
you're ordering it.
would you put the company name, the real estate company name for that agent? Page 5.
Mhm. That'd be buyer or seller.
And then paid by buyer or something.
I would keep it a buyer or seller. I wouldn't want to put you guys on the hook for anything.
Yeah. I agree.
But although usually it's ordered by the agent, that's why.
No, it is, but on behalf of the buyer, right? So
Yeah,
I would keep that as buyer or seller. I wouldn't put buyer or listing agent or
Okay.
Keller Williams or anything else. Any other questions about the home warranty? All right, casualty. What are we talking about here? If it burns down, blows down, right? Something happens, act of God, or some part of the property is destroyed. Buyer or seller will have the right to terminate the contract within 5 calendar days of receiving notice of the casualty, either party, right? Buyer or seller must deliver written notice of termination. So that's again, that form you got. There's all kinds of places in here where buyer or seller has the right to terminate the contract. That's the form that you use in order to do that, a unilateral communication. If there is no notice to terminate, then the contract stands. So if nobody terminates the contract, right, within 5 calendar days, within the 5 calendar day period, then we're still closing, okay? But the seller has to either repair the damage, they got to give the buyer the money to make the repairs, or they've got to assign their homeowner's insurance proceeds to pay for whatever those amounts are, and the seller would be responsible for paying for the deductible.
Wouldn't the mortgage company get involved in that?
More than likely, depending upon if there is a mortgage and whether or not the repairs can be, it depends on how bad the casualty is, right?
Hurricane.
Yeah, I mean, if there's a total loss or something like that. Now, if there's a portion of the shed that burned down, the mortgage company is listed on the policy as an additional insured. But if they're not worried that it's affected the value of the property, they may not care. But it kind of depends on how bad the damage is. So if you want to terminate, either party has to terminate within 5 calendar days of having notice that a casualty has occurred. However, if it does not get terminated, the seller is on the hook for repairing the damage, paying for the repairs, or for assigning their insurance proceeds. So make sure the seller knows if the seller wants to get out of the deal, they have to deliver the notice of termination during the 5 calendar day period. Property disclosures. You guys have probably already vetted this with Tracy pretty well, but obviously you're going to check off if a disclosure is being provided. If you got a buyer, you kind of want to think twice if the seller does not want to provide it. What's the specific reason, right? Because the buyer and seller can agree not to provide a property disclosure. If the buyer and seller agree that one's not going to be provided, that's an exception to the rule that one has to be provided. But you don't want to agree to that unless you know why, right? There may be some circumstances, there may be an estate involved, right? Where the personal representative does not know anything about the contract or doesn't know anything about the property, and they just are unwilling to sign a disclosure. You know, I would say, look, just put no representation on it. That way, at least you got one. But there will be some folks that will refuse to, but know why they're refusing to before you agree to that. All right, lead-based paint, you guys should know that. If it's built prior to 1978, you got to have it. Get your disclosures executed. If you don't, there are fines up to $40,000 that are on the books. So that is a costly mistake. Make sure that your client is not in that situation if you're representing a seller. Sex offender registry as well. This part is in here, but basically this says that you as the agent are not responsible for anything. All right, it's up to the buyer if they're interested in figuring out if there's anybody on the registry which is in a certain distance from this particular property. It's up to them to look. And the main thing I want to impress upon you guys here is don't make a opinion or give an opinion or a recommendation, because that then opens you up for liability. This gets you off the hook. This says, I'm not telling you anything about it. It's up to you, buyer. But if you give them an opinion and they tell you something and you tell them something about it, you make a representation, you are now opening yourself up to liability, because now instead of agreeing that the brokers are not responsible for obtaining any information, you have unilaterally given that information. So don't volunteer anything. All right, withholding taxes. You guys know what withholding taxes are? Everybody, huh? That's impressive. You have an out-of-state seller and they sell a piece of property here. The South Carolina Department of Revenue is going to require that 6% of the gain on the property is paid to the Department of Revenue. Okay, which is a problem if we're just dealing with that at closing. So we figure out at closing that, oh, wait a second, you don't live here. And we are
Out
having
of state or out of country?
Out of state. This is Department of Revenue withholding taxes. There's also federal withholding taxes if you are not if you are a foreign citizen and you're selling property, which is higher. It's 10 or 15% of the gain. So we got two different issues. The one we deal with mostly that you're going to be dealing with is state withholding taxes. Now, there are some exemptions to having to pay state withholding taxes. If this was your primary residence and you've moved, right? You lived here for 2 of the last 5 years, you weren't renting it out, you're exempt. If there is no gain, there's 6% and 0 is what? 0, so we don't need to collect anything. So if you're selling it for a loss and there is no gain, we don't need to worry about it. But if you were using this, or if you were renting this out at any point in time prior to 1997, and you were selling it and you no longer live in the state of South Carolina, you're not gonna file an income tax return in South Carolina this year, you gotta pay this. Okay, and sellers are never happy about this when we inform them 2 days before closing, when they see the settlement statement and there's this withholding tax on there, right? Now, this contract actually deals with this and makes them aware of this now, so you get an easy out, you can point to the contract and say, it says it right here, right? But you guys do need to be aware of this, and from a FERPTA perspective, if you're a foreign citizen, when you sell real property, you'll have to pay a federal withholding tax to the IRS as well. Yep.
We skipped trust account interest, charitable contribution 19.
Oh, look at that.
It's not a big deal.
So which one do we check? Because the broker, we're not putting the money in our broker account, we're gonna send it to the closing agent.
I wouldn't even check it. I would disregard it, because you guys are not gonna be holding the earnest monies.
Well, technically,
Anytime, I mean, we're not-
broker may not place deposit or money into it because we're not depositing it, so.
Okay, so we're gonna check, we're done. Okay.
I mean, to be safe, I put may not, because if it's an attorney,
In May.
if it's an attorney,
All right.
if it's an attorney holding it, we can't hold it, we have to hold it in an IOTA account, which is non-interest bearing. So if you're not holding it, if the agency's not holding it, then you can check may not, but it really doesn't matter because you guys aren't depositing the earnest money.
Okay. Thank you.
Good question, man, you are looking at these paragraphs, I like it. I don't even know I missed that one. Merger clause, pretty simple, make sure everything's in writing. No emails, no texts are applicable as far as binding the buyer or seller. Everything needs to be in writing, signed by both parties, other than the notice of termination, which is a unilateral communication. Prorations, all right, now these are a little bit different than CCRA as well. Utilities, utility bills, garbage bills, HOA fees, taxes, rent, security deposits, all of that typical stuff is prorated from the date of closing, okay? How is it prorated? This is different from the CCRA. Instead of requiring us to use the last issued tax bill, the closing agents are able to use the most accurate information available, which means if we're in a situation where we've got an investor selling the property to somebody that's going to use the property as their primary residence, we don't need to prorate based off of the 6% amount. We can prorate off of the estimated 4% amount because the buyer will have to apply for it, but should qualify for that lower amount. And that's the most accurate information available, okay? So it gives us a little bit more flexibility with regards to prorations instead of having to always escrow based off of the 6% in situations where investors are selling.
Will the tax agency adjust that 4% immediately based on closing date?
Nope, they're gonna do it for the whole year. You only have to live in a property 1 day as your primary residence in order to qualify the entire year for the lower tax rate. Special HOA assessments. When were they approved? Let me know what a special assessment is. So we got annual dues, we got capital contributions, we got all kinds of fees that the HOA is charging. But if we got private roads, or if this is a townhouse, right, and we got a block of 6 townhouse units and the roof needs to be replaced, or there's private roads that need to be resurfaced, the monies that go into paying for that are community funds, but those are through special assessment because you're not paying for that every year. Those are not recurring charges. So if the special assessment was approved by the board prior to closing, seller's got to pay for it. If that special assessment was approved after the closing, even if it's been contemplated, then it's the buyer responsibility. All right. So again, check your disclosures. If there's something in there about special assessments, then you need to make sure that you're doing a little bit of investigation. It also says that the parties will settle up if for some reason the prorations are incorrect. The parties are on their own to true up whenever those bills become due and the actual bills are issued.
But if we go back to earlier here, it says that we accept all that stuff from the buyer accepts all that stuff from HOAs and this and that and the other thing.
But we're talking about covenants and restrictions there. We're not talking about specific fees.
Okay, thank you.
So we're talking about what the rules and regulations of the community are. Default, if you are the, if you haven't done what you're supposed to do, then if you are the non-defaulting party, you can terminate the contract and sue for damages, or you can recover attorney fees and court costs, all of the above. Mediation, if you're going to pursue suing somebody for breach of contract, you first got to go through mediation, right? Which means you're going to have your attorney, other parties going to have their attorney. There's a third attorney that's going back and forth, trying to listen to everybody and proposing a solution to hopefully split the baby and not have to go forward with the litigation and actually spend more time and court costs and going to court. It is non-binding, however, right? So mediation is different than arbitration. Arbitration is usually binding, which means you're never going to court. Whatever the arbitrator says is final. But mediation is not the same. It's just a attempt to help settle the claim before it goes to court. But if it doesn't get settled, then either party can continue with the litigation. Non-reliance clause. Again, nothing but what is written in the contract or assigned addendum is going to be valid or enforceable. Broker disclaimers in paragraph 26. Again, all this is for your protection. If you represent something to the client, you better be right. Because this says the brokers give no warranties or representation. So if you go out on your own and you give a representation, you better be right about it. Otherwise, you can be held liable for misrepresenting something to your client. Now, this is tough, right? Because what are the clients hiring you for? Your expertise, right? So again, you want, if it's in your wheelhouse and it's something that you're dealing with from a transactional perspective on a day-to-day basis, good. Give them your experiences. Service your client. But if it's something about repairs, if it's something about the sex offender registry, or any of the other various things which are outside of your lane that could come up, you need to hesitate on giving any kind of a opinion or warranty, because you want to refer them to the inspector, refer them to the appraiser, refer them to the lender. Don't put on a hat that you guys don't normally wear, because that opens you guys up to liability. All right, broker's compensation. All right, let's get you paid. Party, this is different too. I don't think this is in the CCRA contract. Correct me if I'm wrong, Tracy. If there's a dispute about commission, okay, we don't want the closing. We don't want to hold up the closing because the agents are arguing about commission. So this contemplates continuing with the closing, but if there's an argument about commission, then the commission money gets escrowed. And the parties can either work it out, or the escrow agent or the closing attorney can then within 6 months can send it to the court for an interplea, okay? Otherwise, the attorney is also authorized to give it to one of the brokers who cannot pay anybody until there's a resolution of that as well. All right, contingencies, other terms. Now in paragraph 28, be aware that your most recent addendum controls the contract, right? So if you've got multiple addendums all dealing with the closing date, the last one that was executed is the one that controls the contract. You need to list the state-specific association approved addendums in this particular paragraph. This is where your closing contingencies, closing and sale contingencies, or any other various contingencies that are already been pre-drafted by the Realtor Association, and their form numbers you would include here. This is not like paragraph 18, where you guys can insert whatever you want to. That's not the intent here. Yep.
CCRA or whatever, is that other contract?
Yes, Central Carolina Realtor Association.
Okay, so this is the Realtor Association contract.
This is the State Realtor Association contract. And our MLS, our Realtor Association, has its own separate contract that they normally use.
Makes it simple.
Lovely.
That's where all those dues are going.
That's why we're here. All right, expiration, paragraph 31 creates a rescission period for buyers or sellers to be able to rescind an offer. This is a blank that you are going to fill out in paragraph 31. So when you make an offer, if it hasn't been accepted, it doesn't say that it's good until a certain time period. It says that you can rescind the offer by a certain time period, okay? And it's gonna terminate automatically if it's longer than 30 days, if it hasn't been rescinded by the certain time period. But what that means is you make an offer, if a better offer comes in, right, or you find a different house that you want to buy if you're on the buyer's side, you can rescind your offer to the seller if it has not been accepted yet, and then you can make an offer on another property. But you got to do it in writing. And again, that's what the last bullet point's for. Before you making multiple offers, you certainly want to rescind the initial offer before making another offer, because you don't want your client stuck contractually obligated to buy two different houses.
So maybe not necessarily you, maybe to Tracy, what kind of date and time were we putting there roughly for working?
I think it's going to be market. I mean, it seems to be a recurring theme, but it's market dependent, right? If you want to put, if there's a lot of buyers out there and you want to put pressure on the sellers, you give them a short amount of time. If not, you can give them a longer amount of time. So it's going to depend on how quickly you think, or how many people you think are going to be trying to purchase or sell the property.
I'm confused by the bolded section that, I mean, if you're putting a date there, then why will it say it expires after 30 days? If you put a date in there, doesn't it expire at the time?
Oh, I'm looking at the notice of termination, sorry.
Really?
Double expiration.
When signed by a party intended as a offer or counter offer, this document represents an offer to the other party that may be rescinded any time prior to or expires at a certain time period on a certain date, unless accepted or counter offered by the other party or in the form delivered prior to such deadline. All right, so let's say, essentially, I think that it's limiting it to 30 days, right? So you can't have a 45-day rescission period.
Or do you mean like if it was counter offered, then if there's no reply for the,
Well, it says of no action, so I would think a counter offer is an action. So this is just if it sits for 30 days. Now, I also think this is meant to cover if nobody fills this out. I think that's the most important part about this.
oh, okay.
So if nobody fills this out, the offer is expiring after 30 calendar days.
Gotcha, that makes more sense.
That does make sense. You get that.
It just, they should have had as a separate sentence.
Right. Or added some verbiage to it anyway. All right, legal documentation required if signer is not a party. We've already talked about all of these things at the beginning: POAs, estates, trusts, corporations. Make sure they're authorized to be able to sign and bind those particular entities. Your information is included in here as well, right? So you got a separate section where you're going to put your email address, your telephone number, your license number, and your company and name. So all of that stuff, remember, needs to be included there, especially if you're not going to be putting in the information for your seller, because otherwise there's nowhere to send notice pursuant to many of these provisions in the contract.
David, I did have one more question.
Perfect question.
In regards of the, like just the different documentations that we need to send. When it comes to LLCs, it says corporate authorization. If it's a sole proprietor, can we just send in articles of organization or any of those other associated documents? Because obviously there probably wouldn't be a corporate.
Yes, if you're dealing with a single member LLC, he still needs to be signing for the LLC, not just his name individually. But in that particular instance, a lot of times a single member LLC will not have an operating agreement. That's the one thing you can ask for if they have an operating agreement, which should state that they're the only member. But if I have a single member LLC, you can change the governing rules anytime that you want to. And the only person that's required to do that would be you. So you don't, a lot of times you'll find a single member LLC does not have an operating agreement. If you really wanted to put your legal cap on, you can have them execute a resolution which authorizes the sale of the property and authorizes that particular member to sign on behalf of the company. But we're going to do that at closing. So for single member purposes, I wouldn't be exactly worried about it. Okay. Yep.
Like the last page, it asks for our contact information, our office code, our this, our that. Why do we provide all of that in the contract and then the attorney's office turns around and asks us for all of it as though it's not in the contract.
You're talking about other attorney office, right?
No, I don't.
Well, I'm glad that you pointed that out. The only thing that I can figure would be because, or is it a form email?
So let's just say. maybe
But my
on
guess is there may
on
be
the
form emails that are going out to
information
everybody.
sheets, it's on the, it'll ask for it on, like you gave me, right, so and, a form email, right?
Sure. Well, all agents are not as diligent as you are, and won't include their contact information on contracts. So if you're being asked to send anything, especially when MGC is involved and it's on the contract, just put C contract. Yeah,
Because when you do that, they think you're being rude. No, I'm not trying to do your job, I
No.
already did.
that's what I tell them. That's what I tell them all the time. But yes, no, I understand. Yeah, if you've already given it on the contract, and quite frankly, if you've used this before, we already got your stuff in the system anyway, so you don't have to send that stuff. All right, that was a lot.
Thank you.
Sorry to take up a lot of your time today. Any other questions? All right, something comes up. If you got a great folder, all of my stuff is in there. If you don't already have it, please don't hesitate to reach out and ask us any additional questions. If you haven't seen this contract yet, if you stay in this business, you're going to, all right? So make sure you at least know who to talk to if you don't know some of the provisions of it.
Thank you, David.
Sure, man.
We'll be adding the new contract, CCRA contract, class schedule soon. Hopefully by the end of the week.
All right.
On the buyer's agent. The reason I'm saying that.
I know. Yes, yeah.
So we gotta do
Are you representing SFR3 or are you representing?
Yeah, the new contract goes into effect January 1st.
So are you working with Gary? I thought Gary had this too.
I've seen that one.
Well, you should be. How are you gonna do it? You been doing it, right? Absolutely. That was this. All right. Well, this is very interesting to know. How much of a problem has it been, the latest edict that has come out with regards to purchase prices? I would assume that's how you guys will be heard about
I found out Friday at 6 p.m. It was pretty stressful. We were able to negotiate for the 5. So this one, we're still in the process of not able to say.
We got a bunch of sellers calling us. That's what helps.
Yeah, and earnest money too, because they don't want to give that no.
Right. They don't have- the sellers who agree to change it. I don't have.
Right now, I'm in the process of trying to get portfolio to allow me to make off $2,500 longer. I just gotta renegotiate that total contract stuff. If we can't do that, it's not gonna happen. So,
Well, we're not by our purchase price, right? It's just that one deal.
yeah, we were able to save the other ones.
So hopefully there'll be a little bit more flexible.
I agree.
But I've been with those guys for about 4 years now, so if you have any internal stuff that you have questions about, you may know where to go, what to do, but I've dealt with those guys since it was 4 of them. Now it's obviously 400 of them. So good. That's interesting to know. I did not know that. Were you working with them last year too?
I was, I started in November.
Okay. Gotcha. All right. Well, he'll be invited to the Christmas party this year.
Good. No, if I say anything, give Liz and Allison a raise. I was like, there's sometimes it's, yeah.
They do a good job, but they do have to work hard. That's for sure.
They do.
But let's put it this way.
Was Allison or Liz?
They were not here today,
Okay.
but they are glad that there's other folks
Like, don't leave, don't leave.
So,
You mean like other?
Oh, I just want to stop by.
Oh.
I didn't think I was coming down today, but I was
So,
trying to ask a
that
question
should help
on
some.
virtual, but y'all couldn't hear me.
So,
So I was like,
it's
sure,
good.
I'll just shoot down here.
It's Gary, he didn't necessarily know. Mark,
Thank
So make
you.
sure you get a couple of
There
those.
was
for
some other
sale signs,
issues,
for the
so
open house signs.
hopefully
I have some
you will make
from
their
that.
job.
I think I have like about
I
6.
know, there was a spot 6 months ago. before
Like
they
running
left
around,
the
trying to
people,
install it.
Right, they still on the side. They were thinking about, I don't know if that's maybe
Don't forget
next
the,
year or something. but-
they've been talking about it. I haven't seen it yet.
Okay,
so.
okay. 'Cause I thought it said that.
But any questions that you have, let me know. And now this is good. Now I know an inside track. Is Liz still doing the resales or is she doing the sales or just the purchases? Okay.
So if I could ever get into like whatever I help purchase.
Yeah, that'd be good. That'd be good. All right, well, it's very nice to meet you.
That's me.
I'm sure we'll be in a lot more touch here. Now that we know the parties involved. Thanks, man. Good to see you.
And I'm his admin, do you know me?
I do know you.
It is.
Keeping them straight?
Watch your
head.
She's on me like.
Good job, you
Well,
done.
so Liz and Allison are already like that too. Everybody needs a couple.
Hey,
Yes,
David.
ma'am. How you doing?
Nice, put face with a name. You helped me a couple of months back with an issue I had with, a seller refusing to sign the release.
Right.
Sorry, I figured that. I keep trying to-
Well, oftentimes what I've seen is time cures a lot of things. It doesn't ever happen the way the other party, as quick as the other party wants. But it's better to wait it out than to have to file legal action and there's no money left to give anybody.
And that deal wound up all again.
Did it really?
Yes.
Was there issues with the earnest money on that one or?
We already decided we was gonna get back to it,
Okay.
but they were trying to hold out, and they wouldn't get rid of the dogs out of the house, so the second deal.
Fell through too.
Wound up working out, but it was a good place for it.
You as well. Well, call us anytime you have stuff comes up.
All right, thank you, you have a good one.
Good to see you, Shante.
David, can I grab one of these?
Oh, yeah, I'm sorry.
Okay.
No problem.
Thank you.
You want, I'll leave these too. You think somebody will use, you think anybody else will pick them?
Yeah.
I don't need them.
Can we put them in there in the mailbox? That'll be fine. Okay. Yeah.
Got it.
Girls have on virtual one.
Perfect, because that's got the PowerPoint on it. What you got?
This is Sunny.
Oh,
Jeff was asking, do you think there's a way to make the foreclosure disclosure look like? But you can't, can you get, put like a bill to the nursing home on that?
that's what we're gonna do. I think that's what Kelly did. Did she not do that? Yeah, that $74,000 bill, we're gonna put on the settlement statement. Just for purposes of negotiating the payoff. Now, the problem is gonna be if the attorney wants the final settlement statement. Yeah. That could be a potential problem. Now, if they're just gonna send us a pay, look at it, and send us a reduced payoff, and not care what happens after that, as long as they get the money in the payoff, then that works. But if when they send us the reduced payoff, they say we need to see an executed copy of the settlement statement. That's not gonna work, because that means they're not gonna see that amount on there. Well, it would probably, either through the correspondence with them, or in the payoffs, the reduced payoff letter, it'll have that information in it. If it doesn't, you don't want to pay the $74,000. So if it doesn't have it there, you may have to pay the full amount. Or we can go back to them and say, look, this amount is owed, it's not the lien on the property, so it's not gonna be included in the settlement statement, but this is the amount that's owed, which is why we need it reduced. So, yeah. I think you have a better chance.
But they see before coming to us.
Exactly, that's why I think we need to put it on there first. And let's just let it play out, see what happens, but just be aware, if they want to fully execute a copy of the settlement statements. Problem, yeah. We have to reroute it. So fingers crossed. And it's cover everything. I've seen that before anyway.
All this room for activities here. It's even better.
But yeah.
What did I miss,
I won't say not much because I don't know if that's true. I think you missed a lot.
Oh, no.
Sorry, Christine. That's just my personal opinion. And